May it please your lordship. I beg to mention one matter for, if it is not inconvenient, my lord, to be taken up as unlisted, my lord. It's a medical admission matter, my lord. The counseling will start from day after tomorrow. I belong to the defense quota, the children of serving defense personnel, but my application has not been considered.
Motion matter.
Motion, man. It will start from day after tomorrow.
When did you file it?
My lord, last night we filed it, e-filed it.
Uh-huh.
Today morning it has been, we have got a number, my lord.
You'll have it tomorrow?
My lord. Deeply obliged.
May I please, your lordship? My lord, I have a prayer for listing of a case, my lord. Matter pertains to, my lord, provincialization of service of the petitioner, my lord. This case was supposed to be listed in the month of June, my lord. Unfortunately, not listed till date, my lord. I'm praying before your lordship, my lord, just to list this case on 31st, my lord, last day of this month.
So why don't you approach the registry for that?
My lord, we had approached, my lord, and the applications were also filed, my lord, earlier, my lord. They, my lord, do not
Okay,
provide with
okay.
a certain direction.
May
Okay.
please, lordship.
Deeply obliged.
With the consent of the other side, my lord, I beg to mention item number 9 and 10, my lord.
Yes.
If it please, my lord, my senior Mr. Atik Kapoor is under bereavement, my lord. My lord,
You're for the petitioner.
no, my lord, I am for the respondent, my lord. In this case, IIT. I am being led by Mr. Atik Kapoor.
Okay. Have you taken the
Yes, my
consent?
lord. My learned senior is here, my lord.
Lordship, there is also interim order. And earlier occasion, they had taken time twice, Lordship. That might be reflected that they are short.
How much time do you want?
My lord, 2 weeks time, my lord, because he's under, there's a death in the family, my lord.
Mr. R.P. Kokoti, Learned Senior Counsel for
He's under
the
bereavement.
respondent IIT. He said to be on bereavement. Stop on a prayer made on his behalf and not objected to by the other side. This matter again after 2 weeks on a date to be fixed by the registry.
Lordship, a date may be fixed, it is maybe 6th of.
Interim order is there.
Yes, Lordship.
Interim order passed earlier shall continue till the next date of listing.
Deeply obliged, my lord.
Both the analogous method.
Okay.
My lord.
Registry will give a date after
Hello.
2 weeks. Okay.
Deeply
Okay.
May it please, my lord.
Yes.
Prayer for listing of a motion matter for tomorrow, my lord.
What is the
While
urgency?
the urgency in the case is that, my lord, owing to a interim order passed by this honorable court, my lord, the said respondents, the private respondents, they are enjoying the fruits of the stay. Now, my lord, a notice has been issued regarding conducting of examination for the post. We are all grade 4 employees. Now, the posts have been reduced owing to the said interim order. In fact, my lord, there is a order passed by my lord only in this regard, protecting the service of similarly situated person. If I
Can we have it next week? Next week.
My lord, the exam is going to be conducted on Thursday, my lord, coming Thursday, 25th, my lord.
What exams?
My lord, exams for the said post of grade 4 employees of the said.
You're not participating in that.
We are participating, my
Then?
lord, but posts have been reduced. The post earmark was 17 as per office memorandum. Yes, my lord. Now the post being floated is 9. So, my lord, we are getting deprived of the opportunities, my lord.
So what was the interim order passed?
My lord, the interim order passed in the main in the said writ petition, my lord, was that the OM is not to be given effect to. That was the said office memorandum in question, my lord, was not to be given effect to, and the said petitioners, their services were protected. They are all overage candidates, my lord, the private respondents, whereas
You are seeking for a similar order.
similar order. In fact, there is an order passed by my lord only. May I kindly submit it, my lord?
All right, it's okay.
For tomorrow, my lord.
Have you filed it? When did you file
Yes,
it?
my lord. My lord, yesterday I filed.
Okay.
My lord. I'm filing.
Okay.
For tomorrow, deeply obliged.
May it please, sir.
71 matters. Anyway.
May it be please, your lordship. Lordship, I beg to mention item number 2 to 6, lordship. Matter may be adjourned for 2 weeks, lordship.
2 to 6.
Yes, lordship.
Matter may be adjourned for?
2 weeks, lordship.
Why?
I was seen out of station, lordship. MSK Devi.
Okay, on a prayer made on behalf of Ms. K. Devi, Learned Counsel for the petitioner who is said to be out of station. Matter stands adjourned for 2 weeks on a date to be fixed and be listed again on a date to be fixed by the registry.
Lordship, in this case, interim is there, lordship. Interim may be continued, lordship.
Interim is there?
Yes.
What is the interim?
Lordship, the petitioners are grade 4 employee and the BTC authority make a advertisement to vacate the post, lordship. After that, we have filed another writ petition, and this writ petition.
All right,
is-
interim order passed earlier shall continue till the next date of listing.
May it please, your lordship. I beg to mention item 11 on behalf of respondent university. We require 2 more weeks, my lord, to file our reply.
On behalf of,
Assam Agriculture University respondents.
who's for the petitioner?
Petitioner.
You're there. Any objection? As paid for by learned counsel for the Assam Agriculture University. Further 2 weeks time is granted for filing counter affidavit. List again on after 2 weeks on a date to be fixed by the registry. Yes.
May I please, Your Lordship?
Yes.
I would like to mention item number 20 of supplementary list.
Item number
20,
12,
20, 20.
20.
Lordship, Engaged Council BK authority is out of station. So matter may be taken after 2 weeks.
Who?
BK Das.
Okay.
We taken the consent of the other side.
Item 20.
20.
He has not taken my consent. He has not taken my consent.
Why do you want adjournment?
He is out of session in
Matter
Nepal
was-
for medical.
Okay, then whose consent did you take?
BK Gauti told me that he take consent.
Item 20.
Yeah,
BK does.
BK.
We did not take any consent. Matter was fixed for final disposal today.
What's the matter? Maybe we can.
He's gone on medical ground.
In Nepal.
When is he coming
Eye
back?
treatment.
Hmm?
For eye treatment.
When is he coming back?
Next.
Next week?
Yeah.
1 week? Okay.
But your lordship will give a fixed date on a hearing date, my lord.
The registry will give a date.
Because matter was fixed for, there's an
Oh.
interim order operating against me. And matter has already been decided by your lordship in a coordinate bench. Similar orders are required to be passed in this order. Doesn't need much deliberation. And he's enjoying an interim order.
We'll fix it after 2 weeks on a date to be fixed by the registry. Okay. Let them figure out because so many mention. I'm being told that tomorrow there are 70 matters listed, going to be listed, and I'm allowing motions and all that.
Or your lordship
So-
will fix it after 3 weeks, but your lordship will fix a date. If it is.
No, I have to manually check what are the things. So it's better for the registry to do it. Mr. BK Das, learned counsel for the petitioner, is said to have some personal difficulties to appear before the court today, and that he's out of station. On a prayer made on his behalf and not objected to by the other side, list this matter after 2 weeks on a date to be fixed by the registry.
For orders, item 13.
My lord, last occasion, my lord, by order dated 23/6/2025, my lord, your lordship, whatever. This is 2022 contempt matter, my lord. Pursuant to honorable court's orders, commissioner passed an order by entitlement, already given the entitlement, but did not given effect. Your lordship go to the by order dated 23/6/2025, my lord. May I read, my lord?
Yes.
Mr. P.K. Bora, learned counsel, on the basis of instruction received by him, has submitted that the matter for compliance of the direction passed by this court by order dated 17/3/2022 in WPC number so-and-so is being purged by the respondents. However, in view of a technical issue arising the uploading the checklist in the FinaSum portal, a delay has occurred. Mr. P.K. Bora, learned counsel, has submitted that the said issue would be resolved and the uploading the checklist in the FinaSum portal would be done soon. Accordingly, he submitted that next that listed the further development taking place in the matter would be apprised before this court. It is expected that the consideration required to be made for implementation of the directive passed by this court by order dated 17/3/2022 is complied with at the earliest. Accordingly, registry is directed to list the matter against so on which date the secretary to the government of Assam shall apprise this court as to the development taking place in that matter. In the event the direction passed by these courts are not complied with, by the next date of listing, the Secretary Department of School Education shall also apprise this court about the reason existing for the same. A uploaded copy of this order be forwarded to the Secretary Department of School Education by Mr. P.K. Bora. Today is my lord. My lord, already writ appeal was dismissed on my lord 17/7/2023. Till today, they passed an order in favor of me, but did not give any salary, did not give even to join in my place of posting.
Yes, Mr. Bora.
Well, I have provided the instruction, my lord, already accommodated, my lord. Accommodated, we have accommodated the petitioner, my lord.
Give him a copy.
Yesterday, petitioner called me, no accommodation, my lord. Yesterday evening, my lord, 7:30.
Kindly look at this.
With reference to the subject cited, I am direct to convey the approval of the Government of Assam Department of School Education towards creation of superintendent post so-and-so and adjustment of the petitioner in retirement vacancy post with effect from 1/1/2007 to accommodate Srimati Dipti Das as stipended teacher at fixed pay 1,800 per month, which will be a personnel to her. This is issue compliant so-and-so. No, my lord, today I am received, but yesterday evening 7:30, she called me. No any communication is.
Okay. So this order is there now.
My,
This instruction is there. What do you want to do now?
my lord, yesterday evening night she called.
Now I am providing, my lord.
Now providing the letter. And so many letters are there. Earlier occasion, if honorable permit me, there are so many letters produced. I am producing the same.
You examine and have a word with your client. We'll listen again next week.
Day after tomorrow, my lord.
No, my lord, next week, my lord.
Why?
Next week, next Monday on, he will.
Day after tomorrow, my lord. Because of that, so many letters were already provided before lordship. I am placing the before lordship, my lord. If honorable court me. This is the order. This is Commissioner Secretary passed by the. This is the order. Everything is the creation of superintendent post. And so it's hence this.
We'll have it on Monday. Okay. You have a word with your client.
My lord.
Mr. P.K. Bora, Learned Counsel for the respondent, has produced communication dated 21/7/2025 made by the Undersecretary to the Government of Assam, Department of School Education, to the Director of Elementary Education, and submits that the order of this court has been complied with. So Mr. N. Bora, Learned Counsel for the petitioner, submits that he may be given some time to examine the same and get instructions from his client. In view of above, list this matter again on Monday.
My lord, I am going to the record of the documents. There is no any mention which school I am going to accommodate, on which play, what post I am going to avail. Nothing is there. If I am going to the record of this documents, with reference to directed convey the approval Government of Assam so-and-so, with effect from so-and-so adjustment petitioner in a retirement vacancy post. Which post? To accommodate Sri Dipti Das as the stipended teacher fixed so-and-so. There is nothing. Is there any post, which post I am going to join, which place which schools I am going to join? Nothing is done. So many letters are already, my lord, given, my lord, before the court.
Mr. Bora, you also get some.
My lord, this will be allocated by the director, my lord. This letter was issued by the secretary, my lord. Asking the director to, my lord, to comply this, my lord. My lord, the school will.
My lord, commissioner may appear before the honorable court next.
Director is a party.
Yes, my lord, commissioner secretary to the.
Not a party here, my lord. Here, my lord, this communication is issued by the secretary to the director. Accordingly, director will comply and communicate the petitioner, my lord.
My lord, earlier, my lord, 10/5/5, sorry.
Kindly see, my lord, this was issued by the Undersecretary Department of School and through the Director Elementary Education, my lord.
My lord, 23/6/2025 by this honorable court is very clear, my lord.
School will be allocated by the director, my lord, not by the secretary.
Show me the order passed by this court against which contempt has been alleged.
Yes, my lord.
Page number.
My lord.
The order which has not been complied with. High Court's order.
Yes.
Page number.
Page number, my lord. Page Annexure 3, page 28.
28.
And operative portion onwards, my lord, para 11, my lord. It is second time or litigation, my lord. Para 11, page 34. The second conclusion of this court, the second conclusion of the court was the stand that appointment of the petitioner is illegal. Two teachers were appointed against same post will also be unacceptable in as much as it is petitioner who was appointed prior to other incumbent. Accordingly, purpose of the reconsideration by passing fresh order, authorities would bound by the judgment so and so. Resultantly, thereof order, impugn order has been passed upon perusal order that it is noticeable that the commissioner and secretary had endeavored to make an independent assessment on the claim of the petitioner without binding itself to the requirement of the judgment so and so. The commissioner and secretary went to the question that the recommendation of the expert committee, the petitioner was in the category where she was recommended not for any kind of regulation of salary. Secondly, commissioner and secretary also again goes to back to the question that the petitioner was appointed against non-executive. When there is an effective adjudication by this court that petitioner is entitled to parity with the 33 other teachers appointed pursuant to the select list dated so and so, and the judgment having arrived at its finality, the commissioner and secretary is bound to confine its consideration to the said aspect and not to the venture out to make a de novo
Okay, Mr.
independent
Bora,
decision.
see, this again refers to a judgment passed earlier.
Yes.
There's no fresh order.
No,
It just
there-
says that principal secretary to pass a fresh order.
Yes, fresh order has-
Strictly taking into conclusions arrived at by this court by judgment dated 5/9/17.
Yes,
So we go back to 5/9/17 at page 24. What was the direction?
page 2. Earlier direction.
Yes.
Earlier direction, page 25, 24, my lord.
What is the operative portion?
Para 13, page 23.
No.
On the other hand, litigant shows names, figures, selectly so-and-so, regularized so-and-so by
Page
creation of
para
so-and-so.
15. Para
Yeah.
15.
There would be inappropriate to say that petitioner is not entitled to claim parity relief so-and-so. Para 15. Following the above more particular facts of that speaking order dated so-and-so was passed without affording any hearing, the petitioner whose service was discontinued. I deem it appropriate to remit the matter back to the authority for face consider in light of the observation made in this judgment. The face consideration is ordered to be made by the Commissioner Secretary Department Education and not DE. During the process hearing afforded petitioner impugn order, speaking order so-and-so will consequent order so will abide by the commissioner final decision. Under order, the order exercise would be created expeditiously and preferably within 4 months from today. Thereafter, order has been passed. That was again challenged, and that was also set aside. And thereafter, they pass an order that by giving entitlement. This is the order. They passed the order. Decision. There is now compliance of the High Court's order. The petitioner was heard, the person so-and-so, the office number undersigned, and conclusion arrived at the High Court have been taken into consideration. Accordingly, it is held that petitioner Deputy Das is entitled to be regularized by creation of a supernumerary post. Hence, the department sought concurrence finance department for creation of supernumerary post in respect to the petitioner. Similarly, dispute us. After second order pass, after honorable second order, they pass this speaking order. They says that commissioner secretary says that I'm the entitled that and similar by the same. And thereafter they not executed. Now this contempt is going on. They pass in several orders, nothing to do it.
First order was passed, then the second writ petition was filed. On what ground?
First order was passed, thereafter they rejected claim. Again it come, the honorable court set aside the earlier order, thereafter this order has been passed.
After this order, what happened?
Yes.
No, after this order, what happened?
After this order, nothing do it. They are going, my lord, thereafter they go to the division bench. At division bench, this is the petition.
Okay.
There.
No, this is what? This is in compliance of the court's order.
Yes, my lord, this complaint order, my lord. Order dated 17/7/2023.
Petitioner is
Sorry.
entitled to be regularized by creation of supernumerary posts.
Yes.
Hence, department has sought concurrence of the final. So this is what they've said. And today, the letter which has been produced is that finance department has given concurrence.
Yes, my lord.
So they're in the process
My lord.
of
Yes,
compliance.
Regularly, my lord.
Approval is granted, Mal. Kindly see me. With reference to the subject matter, I am directed to convey the approval of the government of Assam in the Department of School Education towards creation of supernumerary post with effect from 1/1/2009 to 31/12/2016. And
My learned friend
adjustment
said
of the
before a
petition-
lordship that already accommodate, nothing.
This is the order, Mal.
Which place I am going to?
Well, that will be accommodated, allocated by the director, my lord.
So we'll list it after a week then, maybe after 2 weeks.
No, my lord.
We find out where is going to be accommodated.
On Monday, my lord. Otherwise, they are, but if honorable court not issue any strict order, well, otherwise they are not doing it.
What did I say last part?
No.
Yes.
Yeah. Okay.
In view of above, you cancel from there, okay? Not required. He also submits that from the said communication, it is not discernible as to in which school the petitioner is going to be accommodated. Stop. Next para, under the circumstance, Mr. P.K. Bora, learned counsel for the respondent shall take further instructions about the details of the compliance. Stop. In other words, instructions as to in which school the petitioner is going to be considered for accommodation. List the matter again on so and so. We'll have it after some time, 10 days. Let him get the instruction
My lord.
7,
on 11/8.
7, 8.
11.
11. March.
A copy of the, one more line, copy of the communication dated 21/7/2025 produced by Mr. P.K. Bora shall be retained on record and marked as X for identification.
That line may be recorded earlier court's order says that, my lord. On which that the Secretary Government of Cell apprised court, my lord.
Not
It is
required,
not-
not required. Let him get the instructions, we'll see.
My lord. Must-
14,
Just return it. This is item 30, isn't it? This is 14. Review.
After some time.
Pass over. Timing.
15 and 16,
What is this? IA? Here for the respondent,
Yes, Lordship.
IA is for,
Basically, it's for provincialization of third assistant teacher of Savitri Bharali High School, Lordship.
no, IA is for suspension of impugn order dated so and so.
Yes, Lordship. The as per the High Court's order, the Honorable Court was pleased to admit the writ petition and
As per the High Court's order, Honorable Court was pleased to, what do you mean?
Lordship, as per order dated 23/2/2021, the Honorable Court directed the review petitioners to provide all consequential benefits of provincialization to the petitioner, Lordship. Thereby, they filed the review petition challenging that order, Lordship.
Anyway, counsel is not here, we'll adjourn it. None appears for the applicant when the matter is called. Matter is adjourned for 2 weeks.
Date may be fixed, Lordship.
Why?
Because she has not been provincialized, Lordship. And
No, applicant is not here. Why you want a date? What is the
provincialization-
urgency?
Provincialization depends on the outcome of the review petition, Lordship. And she is not being provincialized. The attendance book has been withheld. She is not being made to sign the.
After 2 weeks, on a date to be fixed by the registry. Registry will fix it. Next.
My lord,
Here what? Which case?
this is a review prepared by the state, my lord.
Which case? Which case?
15.
Item
I passed the order now.
15 and 16, my lord.
No one is there for the applicant.
I was late, my lord.
Hmm?
I was late, my lord.
You're for the applicant.
Yes, my lord.
Where's your name? Name is not shown.
My lord, item number 15 with review petition, my lord. This is a,
You are there in the review petition? No.
yes, my name is there, my lord. Mr. R. Mozumdar and my name is there.
Oh, okay. Yes, what do you want?
In any case, my lord, today I am seeking for some accommodation, my lord.
Why?
Actually, I'm not prepared, my lord. I'm not with the bit.
Who has filed this IA? You have filed the IA.
IA filed by my land friend. my
Oh,
lord.
IA you have filed. You say that, you stand on this side and saying,
IA, we have filed lordship for suspension of impugned order dated 25.
what is the order dated 25/3? Mr. Khatania,
Yes.
you are for the review petitioner.
Yes, my lord.
Review petitioner is the state.
Yes, my lord.
Which department?
Secondary division, my lord.
And the opposite party is the
Opposite-
writ petitioner.
Yes, my lord.
So what are you seeking in the review petition filed by the state?
Lordship may kindly turn to page 19.
No, tell me. State wants a review and why you file on IA in that review? What purpose?
Lordship for suspension of impugned order dated 25/5.
What is 25/3? Impugn order. What do you mean impugn order?
Lordship,
You don't challenge orders in review. You just seek review review of an order. That's all.
Lordship, 4 teachers were transferred on their own grade and scale of pay and posted
Now I fail to understand your case. Give me the review petition, please. Mr. Khatania,
Yes, yes, my lord.
you have filed review petition number 94.
Yes, review petition 94, my lord.
94. What you are seeking review of which order?
Review of the order dated, my lord.
There's a contempt petition also pending.
we had filed the contempt petition, Lordship.
Review petition is an afterthought, Mr. Khatania.
My lord,
This is an afterthought.
my lord,
Court passes an order, you don't do anything. They file contempt petition, and later on you file review petition.
my lord, today I'm.
So that you can render the contempt petition useless.
My lord, today I'm little bit handicapped, my lord. My lord, may take it up next week, my lord. So that I can.
Next week, any date can we have?
One. Well, in this case, my lord, I will not be available on 1, my lord. On 5th or 6th, on 6th, my lord. 6, 7, 8, my lord. After 5, my lord. 6, no, no.
4th of August, we have only 5 cases, isn't it? We can have on that. Monday. List on 4th of August.
Well, on 4th, my lord, I'll not be available. That is why I'm praying.
Arey, why?
Well, I'll be out of station for a few days, my lord, from 1st to 5th, my lord. That is why, my lord, I'm praying for 6th. After 6th, any date, my lord.
No, 6th, not possible. Not possible.
Then on 11th, my lord.
11th, we'll try it on 11th.
Oblige, lordship.
As paid for by Mr. N.J. Khatania, learned counsel for the review petitioner. This is the matter on 11th of August.
Oblige, lordship.
You must be prepared on that day.
Yes, my lord.
21 of the supply list.
This was 15.
May I please, your lordship? Lordship, son pertaining to lordship, promotion to the post of headmaster, lordship.
Lordship petitioner is a senior most graduate teacher of a high school, Lordship.
Yes.
Senior season Lexington Code 1.
Who's your senior?
RB Bora. For BTC.
BTC.
Yes, Lordship. Only possible for time.
No, this is listed for orders today. Why?
Yes, Lordship.
What orders?
Lordship, she filed the Lordship affidavit in opposition, and Lordship, I have filed the reply, Lordship. Until Lordship,
The pleadings are complete.
yes, Lordship, yes, Lordship. Lordship, this is a
Who's
forward
respondent
case.
number 2?
Respondent number 2 is the director, Lordship, and the respondent number 3 is the secretary, Lordship. Lordship.
Respondent number 2 has filed affidavit. Or what?
Yes, Lordship.
Will it suffice?
Yes, Lordship.
When was it filed? 21st July.
Yes, Lordship.
And you have filed reply also. Okay. Parties are represented by the respective councils and they submit that the pleadings are complete. In view of above, list this matter on so and so for admission hearing.
Lordship, there is a, Lordship, this matter is a covered case, Lordship. I have annexed, Lordship, judgment and order part by the.
If it is a covered case, why do you file reply affidavit? For what purpose?
Lordship, earlier occasion, Lordship, I was directed,
No, no.
and my learned friend was also directed to submit, Lordship, affidavit.
We'll have a date. Give a date.
28.
28th.
Lordship, can it short date दिया हुआ था तो
That is a short date, very short date.
short date दिया हुआ था
28th is a short date. Otherwise, we'll go to September.
yes sir Lordship.
For admission, item 1.
May I please, Lordship? My lord, this matter, my lord, pertaining to provincialization of post as tutor in ME Madrasa, and whereas, my lord, respondent number 6 and 7 are far junior, and they are being, my lord, provincialized, and therefore their provincialization is under challenge in this case. That is, Lordship.
IA is for what?
Lordship.
IA is for vacation of
For my lord, there is a.
I for my lord,
interim order.
vacating interim order.
interim order.
And on the last occasion, my lord, it is decided that
Instead of interim,
matter
vacating interim
will be
order,
settled.
matter can be.
Yes. And regarding that, my lord, in the writ petition, I have filed the affidavit in opposition.
IA is thicker than the writ petition, is it?
Yes, my lord. Lordship, writ petition may be hard, my lord, because I, my lord, filed on last occasion, my lord, hard.
That's what we'll do. That is what we are going to do. What I'm saying is that your IA is thicker than the writ petition.
Yes, my lord.
What is there in the IA?
I am, my lord, I prayed for vacating the interim order, my lord.
By
On the-
filing so
on
many
the-
documents.
Only one document, that is, my lord, after provincialization of the
Okay.
services of the respondent number 5 and 6, the present petitioners left the school.
Okay,
And-
what is the writ petition? 5846.
Yes, my lord.
You have not filed counter affidavit.
I have filed.
Where is it?
My lord, I have filed on 27/5/2025.
It is not there in the file. Where is that?
Copy also furnished.
Copy was furnished.
No.
No.
Give him
Affidavit
give
in
him this.
opposition,
Give him
opposition.
this.
Affidavit in opposition.
Yes.
Where? Not received.
Just check.
Not
does-
received.
It says no affidavit filed.
No, I also not received. Well, fine.
Order sheet.
Only I have filed. Show you copy. You copy. Affidavit of opposition.
This is the affidavit in opposition.
But copy has not furnished. Copy has yet not furnished me.
My lord, I have filed, but that is not with record, my lord.
So we'll ask the registry to check.
My lord.
You supply a copy.
Yes,
Copy will be supplied to us also.
supplied also.
You have for respondent number.
One copy is there, my lord.
No, your respondent number.
Respondent 5, 6, and 7.
You have filed for 5, 6, and 7.
Yes, my lord.
Learned counsel for respondent number 5, 6, and 7 submits that he has filed counter affidavit. Full stop. However, a copy of the same is not available on the record. Stop. Similarly, counsel for the petitioner as well for the department submits that they have not received a copy. Stop. Learned counsel for respondent number so and so shall furnish the counter affidavit to the counsel for the petitioner as well as
His junior received, my lord.
when
But not. On the very day, 27/5/2025, my lord.
shall furnish a copy of the same to the learned counsel for the petitioner and for the department. If not already done. Stop. Registry shall verify and connect the counter affidavit said to have been filed by the respondent number so and so to the record. List again on so and so.
Obliged. Obliged.
7 and 8.
Your Lordship. My lord, in the instant matter, my lord, the state has taken decision to provincialize my service, my lord. Already they have answered positive in my favor, my lord, by their affidavit, my lord. And before taking my report, petition, my lord, what the contents made by the in my favor, my item number 7, my lord. I'm for the item number 7. Yeah, I'm challenging the post.
Why is it clubbed together?
My lord, item number 8, my lord, he's the private respondent of 7. He separately filed another writ petition by cancellation of his pronunciation order, my lord. Already government has answered in my affidavit, my lord. Their affidavit, state affidavit, paragraph 8, 7, 8 and 9 answered all these things, my lord. Affidavit filed by the government, my lord.
Then I have filed IA, my lord, in WPC 4498.
This is not coming. I'll come. I'll come. You'll get chance.
IF or what?
As a party respondent.
It will not come.
Allowed.
No, my lord, it is first time this.
Well, I don't have any grievance, Lordship. Or after going to the merit of the case, Lordship will decide whether his implement is necessary or not. Already, my case is answered by the state, my lord. So, in the light of their decision by the regarding so far as the provincial is concerned, matter may be disposed of. I don't have any grievance against anybody, my lord.
Then what about the others?
And so far as my lord, as respondent 7 is concerned, my lord, he is the what? My lord, kindly have a look by writ petition first.
Yes.
Writ petition, Lordship, I like to take your Lordship directly, my lord, District Scale Committee's report at page 24, 25, my lord. Page 25. Lordship will find, my lord, recommended considering the enrollment of the school, my lord, 6 teachers were recommended, my lord, and 4 language teachers.
Are you able to read page 25?
Page 25, my lord.
It's hardly legible. It's a format of the report, isn't it?
Yes. My name is Milord, social science recommended, and mathematics, there is no dispute, and 4 language teachers have been recommended.
It is hardly legible. I don't know how they allow you to file these things.
Lordship, it is clear from the then I approached before this court. Lordship will find, Milord.
No, please answer my comments. You cannot just simply ignore what I'm saying.
Yes, Milord.
I'm telling you that your annexure is not legible. Who has allowed you to file all these things? You should file a typed copy.
But a clear copy in the very next item number 8, same scrutiny committee report is available. Item number 8. Lordship may peruse from there also. Same annexure, Milord. In item number 8, page 29, Milord. Same scrutiny committee. It is clear, Milord. Item number 8, page 29. Same scrutiny committee report.
No, we're going to item number 8.
Scrutiny committee report is very
To clarify your thing, we are looking at other things.
Yes, Milord.
Why should we?
So far,
Why should we?
that this report is concerned.
You should make out your own case.
Yes, Milord. Then, Milord, that by this scrutiny committee report, the 6 teachers were recommended. My name was recommended against the post of social science, which demand as per the section 3.1.11 of the 2017 Act, Milord. So 1 language teacher, 1 social science and math, and another social science. Accordingly, Milord, my name is recommended for social science, 4 language teachers. After surprisingly, Milord, the state level committee earlier around the 4 language teachers, 1 mathematics science, Milord, the provincialis depriving me. Then I approached before this honorable court, and this honorable court has found, considering all the facts, directed the respondent authorities if the enrollment of the school is concerned with the beyond the then without considering the who is eligible for this provincialization is directed. Accordingly, my lord, after considering all these aspects, my lord, the authority has done a hearing in this matter and found I am eligible for the post of social science teacher. Accordingly, they have recommended my name, my lord. Since delaying in the process of the recommendation, my lord, so I approached before this court, and the person, my lord, the English teacher, who is not, they have not considered another, which is item number 8 is concerned, my lord. His case has not been considered.
Mr. Deka,
My lord.
you say that you have no grievance with against anybody.
No, their language is I am social science. There is no dispute. I have also enclosed one order here, my lord.
If you have no grievance, then why should we keep this writ petition
my-
pending? We
let
dispose it of, and you withdraw.
I am praying for disposal of my cases concerned.
You withdraw it then.
Withdrawal, my lord, question, some direction is required since government has taken
See,
decision,
the
my lord.
direction is required.
Yes, my lord.
So that means you
As per
still
the
have
decision.
still something has to be done. Seeking for direction. You say if you have no grievance, we simply close the matter.
So given so far as concerned, my lord, they have said that this petitioners, they have recommended my name for provincialization. It is their stand of the state, my lord, in their affidavit, my lord. And so far as language teacher and social science, they are distinguished post, there is no grievance against me, my lord, and that this honorable court in another matter covered case, my lord, already answered this. So far as social science post, my lord, language teacher is not grievance against social science teacher. Is there any grievance? The language teachers, senior, junior come in their case. Lordship, in this matter, page 40, annexure 7, my lord.
Mr. Deka, let us not go in a shortcut thing, okay? You
Yes,
just
my
tell
lord.
me from the beginning
Yes, really, my lord.
what is your case.
Yes.
Okay.
Yes, my lord.
Now this is the second round, I believe.
Absolutely.
Now where's the first round?
Yes.
Where's the order?
Yes, my lord. Page 32. Annexure 5. Page 30, in the order, page 32.
This is the first writ petition.
Yes, my lord. May I read the order, my lord?
You can read from paragraph 3.
Yes. By filing the writ petition under Article 26 of the Constitution of India, the petitioner who is serving in the post of assistant teacher in the Kalapani Sakatun Nisa ME Madrasa in the district of Dhubri has assailed the order dated 4/2/2021 issued by the Director of Elementary Education Respondent number 2, by which the service of the private respondent number 6 to 9 was provincialized. The petitioner has also prayed for directing the respondent authorities to provincialize the service of petitioner as assistant teacher of social science subject and for other reliefs. The Learned Council for the petitioner has submitted the provisions under section 3111 of the 2017 Act. In short, a minimum 3 teachers or tutors are envisaged in upper primary school with at least 1 teacher or tutor each for science and maths, number B, social studies, number C, languages, with proviso to the effect that for the additional post shall be considered in accordance with the norms and standards stipulated in the Right to Children Free and Compulsory Education 2009. This is RT Act in short. In the said context, it has been submitted that as per the present enrollment of the students in the said school is around 236 students, the service of all the 6 teachers of the said school, inclusive the petitioner and the respondent section, ought to have been provincialized. However, the district level scrutiny committee had found the following tutors to be eligible for provincialization of the services in the following seriatim. That is, respondent number 1, respondent number 6 to respondent number 7, number 3, present petitioner, number 4, respondent number 8, number 8, Mehboob Alam Ahmed, and number 6, respondent number 9. However, the Director of Elementary Education 2, by the MP notification dated 4/2/21, provincialized the services of all the 5 tutors by leaving out the name of the petitioner. Thus, it has been submitted that the respondent number 2 had deprived the petitioner without any cause and reason, despite the fact that petitioner was a social science teacher. It has also been submitted that respondent number 6, that taking advantage of the being the headmaster of the said school, had wrongly entered the name in the record as social studies and English teacher, and wrongly entered the name of the petitioner Assamese and social studies teacher. It has been submitted that out of the 5 teachers whose service has been provincialized, there is no dispute with the provincialization of science and mathematics teachers, namely Mehboob Alam Ahmed, for which the order of this provincialization has not been challenged. In respect of the remaining 4 teachers, that is respondent number 6 to 9, whose services have been provincialized, it has been submitted that they are the shown as language teachers in the DLC. Decision recommended, which in contravention of the provision of the section 3111 of the 2017 Act. In the alternative, it has also been submitted that this court in the case of Gulnihar Begum versus State of Assam and 5 others, so decided on 16/9/2021, had referred to the provision of section 3111 of the 2017 Act, and having found that the MA school in question had 91 to 120 enrolled students, disposed of the said petition by issuing the following direction. In view of the above, this petition is disposed of with a direction to the Director of Elementary Education Assam to examine the aspect as to whether the Biraj Mohan Kumudin Datta MA school has number of students between 91 to 120. If yes, as to whether one additional post of teacher can be provincialized over and above the 3 teachers who were provincialized under section 3111 of the 2017 Act. If the director arrives at the conclusion that the school is entitled to 1 additional post of teacher, he would further examine as to which teacher of the school is to be provincialized against the additional post, and in doing so, the case of the petitioner shall also be given due consideration. The requirement of the director to examine and pass the reasons order be done within a period of 2 months from the date of receipt of the certified copy of this order. Para 7, my lord. In the light of the said submission, the learned counsel for the private respondent number 6 to 9, who were the applicants in the connected interlocutory application, has submitted that he has otherwise prepared to make his submission to the effect that the initial entry of the petitioner in service was dehors the then prevailing law in force, as well as to justify the provincialization of the service of respondent number 6 to 9. However, in view of the alternative submission, the learned counsel for respondent 6 to 9 cited those points as and when the occasion would arise in future. The learned standing counsel for the state respondent also reserved his submission in view of the alternative submission so made by the learned counsel for the petitioner. Therefore, in the light of the decision of this court, in the hearing before referred, the case of the Gulnihar Begum Supra, without determining the rights of the petitioner, this is respondent number 6 to 9, this court is inclined to dispose of the writ petition by directing the Director of Elementary Education Assam to examine the aspect as to whether the Kalapani Sakatun Nisa ME Madrasa has 236 number of students. If yes, as to whether 1 additional post of teacher can be provincialized over and above the 3 teachers who were provincialized under section 3111 of the Act 2017. If the director arrives at this conclusion that the school is entitled to 1 additional post of teacher, he would further examine as to which teacher of the school is to be provincialized against the additional post, and in doing so, the case of the petitioner shall also be to be given due consideration. The requirement of the director to examine the past and reasons order to be done within a period of 2 months from the date of receipt of the certificate copy, disposal of the petition interim order so earlier vacated. Now, my lord.
You are a social science teacher.
I'm social science. Page
And
37.
what is the school? What is the name of the school?
My school name is, my lord, Kalapani Sakatun Nisa ME Madrasa. Now it is ME High.
And
School.
how many teachers have been provincialized?
5 initially.
Who are they? In which subject?
My lord, 4 language, 1 science and mathematics.
Science and mathematics.
Science, mathematics, and 4 language teachers, my lord.
4 language teachers.
4 language, leaving aside the social science subject teacher. This is the present petition.
6 teachers have been provincialized.
6 recommended, 5 provincialized.
You said 4 maths and science.
1 mathematics and 4 language teachers. That means 5 teachers provincialized, leaving aside the social science subject. Social science teachers are not appointed.
One mathematics.
Is no dispute, my lord.
And 4
language teachers.
language teachers.
Yes, my lord.
And you are social science.
And social science, my lord.
So what does the provision say?
Yes,
That
my lord.
1 social science teacher also
Yes,
should be
true.
provincialized.
This also answered by this court. I have enclosed 1 order in Annexure 11 here. Next, my lord, page 37. Annexure 6. Very next page. This is an impugn order initially I challenged, my lord. Wherein, sorry, my lord. Annexure 637, my lord. After this order, my lord, the private respondent number 7 terminated, my lord, cancelled his post provincialization. In compliance of the Honorable High Court's order dated 16/3/2022, my lord. Just I read this order. And also based on report of the hearing dated so-and-so, in respect of WPC number so-and-so, in Mosaruf Hussain, this is the present petitioner, my lord. Service provincialization dated so-and-so, the Abdul Karim Mulad, he is the respondent number 7 in the instant writ petition, my lord. Tutor of the Kalapani so-and-so Goripur, hereby this cancelled. That means, my lord, after considering this, the Honorable Court direction, who is the eligible for the provincial or the service, my lord? 1 language teacher's post is cancelled. This is the respondent number 7, my lord. Then 3 remain, language teacher remain, 1 science mathematics,
Number 7, what was he? Language teacher.
Language, Hindi teacher, my lord.
His provincialization has been withdrawn,
Cancelled,
cancelled.
cancelled. Then, my lord,
Why? Why?
my lord, as per 3111, my lord, Lord, sir, I will come. Certain developments, I will take you
No,
one
there has to be
another.
a reason. You come to that later or now, you come to it now. Why his provincialization has been cancelled? Because provincialization has been done in excess.
My lord, there in their order, there is in that they have thereafter, my lord, certain anomalies they have found in the regarding, my lord, in the records, my lord. So after considering all these records, they have considered only 5 teachers will happen, not 6 teachers. They have decided that only 5 teachers will be provincialized. So far as my school is concerned, my lord.
So what are subjects? What are the subjects?
That is,
Five teachers.
Yeah, that is reflected in page 40, my lord. Annexure 7. This order I like to read, my lord. For non-consideration order, I am before this court, my lord. That is on 21st June 2024, my lord.
No, this again refers to some contempt case.
This order was placed before the contempt case, my lord. So accordingly, contempt case was closed, my lord.
No, that doesn't make the sequence. You have to go in sequence.
Yes.
First, I filed this writ petition number 2143.
My lord.
Order passed on 16/3 so and so.
My lord.
This matter was not complied with, so I had to file a contempt.
Yes.
Contempt during the pendency of a contempt. This order was passed.
Yes, my lord.
You make your submissions in sequence. You're going here and there. I don't know.
My lord,
It
since
becomes difficult to understand.
This order, his provincial cancelled 2023. Therefore, I have annexure 6, my lord, and close it. Prior to this, his post was cancelled, my lord.
Maybe. You go in sequence. You make your submission
Yes, absolutely.
in sequence.
Yes, my lord, I do.
So ultimately, your writ petition, your first writ petition was disposed of
Yes.
with certain directions at paragraph number 9.
Yes, in the light of paragraph number 9.
It does not say that some of the provincialization should be cancelled. It just says that whether the school is entitled to one additional post of teacher.
Yes.
If the school is entitled to one additional post of teacher, you also should be considered. This is what the direction says.
Yes, my lord, earlier. And admittedly, I am the social science teacher, my lord. As per 3111, 2017 Act, my lord.
What is 3111? Let's see. You keep on saying 3111. Education manual. What is the name of the act?
Madam, this is the education manual.
I have this also.
Page number 111.
Tell me the name of the act.
This is Assam Education Provincial Service and Teachers and Reorganization of Education Institution Act 2017. Page 111. Same book. Triple one, my lord.
You come to 108. Plus, first you read section 3108.
Yes. The eligibility criteria for selection of the education institution for provincial service of teachers and tutors. 1. Subject to the provision of this Article 30 of the Constitution of India, the following categories of venture educational institutions shall be eligible for being considered for provincialization of the services of their teachers and tutors. 1.
Not 1. You go on to 9.
Sorry.
We're not concerned with 1, isn't it?
Roman 9, my lord.
Yes, we are concerned with Roman 11.
Yes, I'm concerned Roman 11, my lord.
That's what. Read.
In case of venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics, B, social studies, C, languages. Provided that for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under section 19 and 25 of the Right of Children to Free and Compulsory Education Act of 2009, my lord. That means, my lord, The three teachers must be there, one mathematics, science and mathematics, number one social science teachers, and rest is language teachers, my lord.
So science and mathematics will go together.
Science and mathematics is
One
go
teacher.
together.
One teacher
One teacher.
teaching science and mathematics
Yes, my
also.
lord.
And number two is social
Social
studies.
Yes,
Social studies means social science.
social science.
Then the third is language.
Language.
So three teachers will be there.
If the enrollment is below 100, my lord, then three teachers ought to be. If the above is 100, then it's come right to fair compulsory education, additional teachers questions come, my lord.
The provisor will come in.
Yes, my lord.
Now, in the present school where you are working,
Yes.
how many teachers are
And
there?
my lord, they have provincial is 5 teachers.
5 teachers.
Recommended 6, including me, my lord, but they have provincial is 5.
No one from the social studies.
No. Therefore, I am before this court.
Okay. Then this order was passed.
Yes. Can I read this order, my lord?
No, just a minute. In your first writ petition,
My lord,
the order at paragraph 9,
my lord.
it does not interfere with the provincialization of anyone.
No.
It just says that whether one additional post can be considered or not.
Who is eligible, my lord? This provincialized, my lord.
Ah.
And ultimately, this they have department has found that 5 teachers, they can accommodate for the province only 5 teachers, not 6. So accordingly, they have considered 3 language teachers, 1 mathematics and 1 social science. My name was recommended, my lord.
Okay. So by this annexure 6,
Annexure 6 is
respondent number 7,
he's cancelled, my lord.
he's a language teacher.
He's a 4th language teacher,
Okay, he was cancelled.
cancelled.
Then thereafter, what happened?
Thereafter, my lord, since during pendency of my contempt case, my lord, this order was placed before this court.
No, you tell me about the contempt case. Why did you file contempt
The
case?
contempt case, my lord, then, my lord, after this honorable court has passed that is the first order, my lord, that is 16/2022, they are doing nothing in this matter, my lord. And so I approached before this honorable court. They are sitting silent about the matter, my lord. Then in contempt case, this order has passed. They have said it.
When did you file the contempt case?
Yes, my lord.
When? What is the case number?
Contempt case number 95 of 93, and it's at 8 page 42.
Contempt case number?
95 of 2023, page 42 is the order, my lord.
When did you file it? There is a question.
My lord,
Is it prior to annexure 6 or after annexure 6?
I need to verify, my lord. We filed it on, my lord, 20th February 2023.
Filed on
February 2023.
date
My lord, 20, it is in the FA 20,
22/23.
23.
Okay. Then that means only after you file this contempt,
My lord,
this annexure 6 order was passed.
passed.
Correct?
Yes.
So provincialization of respondent number 7 was cancelled.
Cancel, my lord.
Then thereafter what happened?
Thereafter, my lord, the during pendency of my contempt case,
Hmm.
annexure 7, page 40 order placed before this court.
Okay. Now annexure 7, what is it about?
Yes, my lord. Yeah, their findings, my lord. This the order I like to read, my lord.
This also, I don't know. You should have you should have annexed a typed copy. Because things are so minute and not so legible also. Next time you should
Yes, absolutely, my lord.
ensure that you
Absolutely.
make a typed copy and
Absolutely.
file it.
Absolutely. If
24.
your lordship, my lord, lordship in trouble, my lordship giving some time, some days, I will type, my lord. Otherwise, my lord, I don't wish to trouble your lordship.
No, you go ahead.
Yes. Whereas-
we'll try to
Can I
read
read,
it.
my lord?
Yes.
Whereas the Honorable High Court passed in order dated 24/4/2024 in COP number arising out of WPC 2143/21, just get the order below, stating the issue arising in subsequent proceeding, that is WPC number 4628/2023, has got no nexus and or connection with the direction passed by the court by order dated 16/3/2022. I'm sorry, my lord, I again posted in the first second line one WPC 4620 or 2000 mentioned, my lord. That is the item number 8, that cancel on an order challenged by the respondent number 7. That is also meant, this is WPC below. Then this honorable court,
No, WPC 4628 filed by whom?
by
Respondent number 7.
7, when
Yes.
his provincial order cancelled, he filed and got an interim protection in the matter, my lord.
It's still pending or disposed?
This item number 8.
It's still pending.
Yes, my lord.
What is the interim order?
That matter state, my lord, that is interim order I have enclosed here, my lord.
The cancellation order is stayed.
Yes.
Yes, stated. my lord.
Okay, let us not get bothered with that. You
Yes.
read the second paragraph.
Yes. The Honorable Court passed an order 16/3/2022 in WPC 2143/21 with a direction to the Director of Elementary Education Assam to examine the spec as to whether the Kalapani Sakatun Nisa Emi Madrasa has 236 number of students, and if yes, as to whether the one additional post of teachers can be provincialized over and above the 3 teachers who were provincialized under Section 3111 of the 2017 Act. If the director arrives at his conclusion that the school is entitled to one additional post of teacher, he would further examine as to which teacher of the school is to be provincialized against the additional post, and in doing so, the case of the petitioner shall also be given a due consideration. Whereas the DEEO, the Thuburi, submitted a proposal with recommendation of the District Scrutiny Committee, Thuburi, for the provincialization of the services as per the 2017 Act against so-and-so school. This is a chart, my lord. The Kalapani School Madrasa, the name of the teachers, that is Abu Tahir Sheikh, Sikandar Ali, Mosarraf Hussain, this is the present petitioner, is the subject is social science, and Mehboob Alam Ahmed, math and science, Kasem Ali, language, Abul Karim Mullah, this is the respondent number 6, language. That means, my lord, as per scrutiny committee report, 4 language teachers, 1 social science, mathematics, and social science for Mosarraf.
Okay, the question is whether one additional post is required or not. That is not mentioned.
That is there, my lord. Whereas the Govt Elementary Education Department has constituted a 4-member committee under the chairmanship of R.C. Jain, IS retired, chairman of SEBA, to examine the proposal for provincialization of the services as per Act 2017 by Gov notification dated 18/3/2019. Whereas as per the minutes of the meeting of the committee to constitute held on 24/7/2020, the decisions were taken to instruct the MD Sencho to verify following DICE related parameters of proposed schools and teaching staff of the venture LP and recognized UP upper primary school. Number 1, whether the name of the school appears in DICE data maintained the NUEPA New Delhi for the year 2009 or before. Number 2, whether the name of the incumbent appears in DICE data 2011 and afterwards. Number 3, enrollment position of the school during 2016-17 and 17-18. Whereas the SSA Assam submitted in DICE data wherein it was shown the enrollment position of the Kalapani Sakatun Nisa Emi Madrasa for the years 16-17, 17-18, 170, 137 respectively. Whereas as per the clause 3111 of the Act 2017, the Kalapani Sakatun Nisa Emi Madrasa, now ME school, was entitled for provincialization of service of 5 numbers of teachers based on the enrollment position of 170 during 170-18. Whereas the DICE related information as received from the SSA, Assam was placed before the SLSC as well as the Joint Committee. After due verification of both the committees recommended the following 5 numbers of teachers for provincialization as tutor against the Kalapani Sakatun Nisa Emi Madrasa, now ME school. Thereafter, this office submitted proposal to the Gov for the creation of posts of tutors in respect of the above mentioned teachers against Kalapani Sakatun Nisa Emi Madrasa, and upon receipt of the Gov sanction of the post of tutors, this office issued provincialization of services order of the following numbers of teachers. This is Abu Tahir, Sikandar Ali, Mosarraf Hussain, Mehboob Ali, Kasem Ali, and Abdul Karim Mullah. In view of the above, the Kalapani Sakatun Nisa Emi Madrasa is not entitled for provincialization of services more than 5 teachers as per the 3111 of the 2017 Act based on enrollment for the year 16-17 and 17-18. This has the issued compliance of the Honorable High Court, so 2021. That means, my lord,
So they stick to only 5.
Only 5, stick to only
So
5.
who will be included now? Who will be included? You're not included?
I'm in social science teachers, my lord, and by that time, the hearing conducted SLC, my lord, state level committee, and my name is recommended. That is India affidavit, my lord. Government has
Okay.
recently filed affidavit. My name has been recommended for provincial election. Then, my lord, in the similar situation, my lord, one social science research, my
How
lord,
many teachers were placed for consideration? All these teachers in the order at page 40.
yes, my lord,
There are 6 names,
yes.
including the petitioner.
Yes, 6 were recommended, but out of 6, they will only consider the 5 teachers.
Only 5 teachers.
Teacher.
One has to go.
One has to go, my
Who
lord.
will go?
Then
Respondent number 7 has already been ousted.
he's the
But
junior. He's the junior most teacher.
but there's a stay from this court.
Yeah, yes, in 2023 obtained stay, my lord.
There's a stay.
So therefore, my lord, my progress is no progress in my provincial election, my lord. He obtained one stay order, my lord. And in that instant matter, last week, my lord, government has filed affidavit. Their stand is clear that they have already recommended my post for provincial elections for social science subject, my lord.
Where is the affidavit?
Yes, my lord. They filed on 17 July, my lord.
Which paragraph?
Paragraph 8, 9, and 10, my lord. From paragraph 7, I will read, my lord.
Read.
That being aggrieved, the petitioner approached this honorable court in WPC number 214321, seeking a direction of this honorable court to provincial services assistant teacher social science subject. Similar other writ petitions were also filed against the different schools, and in respect of Dhubri district, total 10 cases were filed, and one such cases being WPC number so filed by present petitioner. Accordingly, in terms of the orders of this honorable court, in those writ petition, verification of recommendation has been carried out in the following manner. Para 8, my lord. That a meeting of the state level scrutiny committee was convened on 12/12/2022 with regard to the court cases filed in respect of provincialism service under Act 2017. Under the chairmanship of the answering deponent, accordingly, an inquiry has been conducted to verify the documents of 10 RUPs and under Dhubri district as per report submitted by DEEO Dhubri with recommended
What is RUPs?
RUP.
Documents of RUPs?
Sorry, RUP. RUP means
Documents of 10 RUPs.
RUP. RUP. 10 RUP. RUP. 10 RUP.
Verified documents of 10 RUPs.
10 RUPs.
What is the full form of RUPs?
Yes, yes.
So these are the questions to be asked by the departmental council. On receiving the Parawise comments, you should ask, what is this? Clarifications. Anyway, please continue to read. Upon verification.
Dhubri with recommendation of the DSC Dhubri for provincial election under Act 2007. Upon verification, in respect of the petitioner's school, discrepancies have been found in the recommendation of the teachers as the names of the teachers recommended are different in hard copy in prescribed format and the copies of the prescribed format sent through email. Further, more than one language teachers were provincialized in violation of section 3111 of the 2017. That accordingly, in view of the above, the committee examining the stated facts and in pursuance of the DICE verification report of SSA Assam and the name of the petitioner found placed in DICE data for the year 2011-12 and afterwards as per the minutes 24/7/2020 of the joint committee constituted by the Government of State level scrutiny committee decided to recommend the name of the petitioner as social science teacher/tutor against the Kalapani Sakatun Nissa ME, now ME school, to the Government of Provincialization of Service as per 2017 Act by cancelling the service of one of the language teachers, junior most amongst the language teachers. Then the
Beg your pardon, it's rural upper primaries.
yes, that the answering deponent humbly begs to state that respondent number 7, herein namely Abul Karim Mullah, whose service was initially provincialized as tutor along with 4 others against Kalapani Sakatun Ebi Madrasa by notification 4/2/21, which is also under challenge in the writ petition, present writ petition, approached this honorable court so and challenging the order dated so passed by this answering deponent, whereby the provincialization order dated 5/2/21 in favor of the respondent number 7, Abdul Karim Mullah, has been cancelled. This honorable court filed order dated 11/8/2023 passed in WPC number so filed by the Abdul Karim Mullah, the respondent number 7 hearing while issuing notice in the interim suspended the order dated 18 July 23 passed by the answering deponent has been stayed until returnable date. That is their stand, my lord. And report scrutiny committee's report enclosed 1 annexure 1 page 75, my lord. What is the decision, my lord?
75.
Yes, they have enclosed it, the report.
What is the date?
That is, my lord, 12/12/2022.
12. SLC.
SLC, state level. Sorry, state scrutiny committee.
12. 22.
Yes, my lord.
This provincialization of respondent number 7 was cancelled on the basis of this or what?
Yes.
Of this 12 of this SLC,
SLC,
SLSC.
SSLC, state level scrutiny committee.
No, have you understood what I'm saying?
Yes.
Provincialization of respondent number 7. Was it cancelled on the basis of this minutes of the SLSC?
My lord, this answer, my friend might highlight on this point. So what is the decisions, my lord? It is here, my lord.
You come to page 37.
Yes, annexure 6.
It says based on report of hearing dated 29/5/23. So hearing was done. So on that basis, this cancellation order came. This SLSC is different. What was the purpose of sitting SSLC? SLSC?
In the very top, my lord, in the annexure 175, they said that the minus of the minutes of the state level scrutiny committee regarding court cases filed in respect of the provincialization of services under the 2017 Act. Court cases.
Court cases, that means not only your case, other cases also.
Other 10 cases. They have considered 10 cases
School, basically.
in Dhubri.
In Hubri, which Your Lordship has queried on the last occasion regarding the 10 RUPs, the 10 rural upper primaries, and the names have been given here, my lord, and these are the cases. Your Lordship sees at the bottom, table A. There the, my lord, names of the schools have been mentioned, and the petitioner's school also is mentioned over here, my lord.
Number 4.
Kala, Pakoni, Hakatun.
Serial number 4.
So, my lord, at serial number 4. So there, my lord, the whole report has been given, my lord. They scrutinize the schools and following report. My lord.
This is following the courts, the court cases.
In Dhubri district, 10 cases of the different schools.
Now, whether the court case filed by respondent number 7 is also considered by this. Respondent number 7. Respondent number 7 has filed 4628. Writ petition 4628 of 2023.
Page 77 in the decision, my lord, it is certain highlighted, my lord. Why?
No, please answer my question. You are clear about your case. 2143 and the present case. Respondent number 7 has also filed a writ petition challenging the cancellation.
I filed the case on 9th August 2023.
Looking at this thing, his case is not there, my lord, 4628. However, he has made a petitioner, the main case has made him a party in his case, but in his case, he's not made any private response party. So if you.
Oh, why should he make them a party? Because he's basically against his cancellation.
From serial number 1 to 10, his case is on. In serial number 1 to 10, 4628 is on. Because WPC numbers are there.
77 decision to the junior good.
WPC is there, isn't it? 4628, is it?
Yeah.
Oh, it's not there.
However, final decision of the committee, which for which it sat, that is given at page 77. The final decision, the points which they consider, everything is given there, and the final decision has been given at page 77, which my friend will read.
Yes, go to the final decision.
May I read, my lord?
So this, by this, you have been recommended, isn't it? 2022, you are recommended,
Yes, my lord.
is it not?
Yes.
You are recommended that. What about the respondent number 7? What will happen?
And since as per their decision, they are going to consider only 5 teachers, my lord. Out of 6, 1 has to go. Then social science is the compulsory subject as per the 3111 Act. So mine have been recommended for the provincialization, my lord.
Page number 77.
Yes, decision.
You are at serial number 4.
Yes, my lord.
You're recommended
Yes.
for provincialization. No additional post? Is there any additional post to be taken? No.
In the decision, my lord.
My lord, one more thing they've given here, in addition, as clause 3111 of the Act, there is a provision for provincialization of one language teacher, but in the instant cases, service of 2 language teachers have been provincialized. Therefore, the committee, after threadbare discussion, decided for consideration of provincialization of services of only one language teacher who is senior among the 2 tutors provincialized against each school.
I am the senior, my lord.
In this regard, the committee instructed DESM to verify the records and take necessary steps for cancellation of provincialization services of the junior language teacher following all procedure as per norms by giving opportunity of hearing to concern.
Junior.
Junior. Whoever is junior.
Who is junior?
I am the senior, my lord. The IF filed by the learned friend, my lord.
Yes.
Yes, my lord. He is the junior most language teacher according to the report, my lord. And therefore he is before this honorable court, my lord, filing IF for implementation.
See, Mr. Kaushik, the writ petition filed by the petitioner, Mr. Dekas Karlain, It was disposed of on 16/3/2022. Disposed of on 16/3/2022, correct? And this SLSC has passed this recommendation on 12. Oh, this is 12/12, is it? Okay, I thought it was 12/2. 12/12. So petitioner has recommended, and it says that the language teacher, the senior one will be retained, is it?
Yes. Yes, the senior one will be retained, junior one will be cancelled. And the junior this thing is being represented by, he's filed an IA. I don't think the IA has been impleted.
Not yet.
Not yet.
Thereafter, the committee, after a threadbare discussion, decided to consider provincialization of the service of one language teachers who is senior among the two tutors provincialized against each school. In this regard, the committee instructed so-and-so to verify.
Following one procedure.
So what steps have been taken pursuant to this 12/12/2022?
Because of the pendency of the case, second case may not, he's gonna stay. So the thing is sub judice. That's why may not now subject to the outcome of the cases may not further this thing will be taken because the other case may not stay. He's with the
See, Mr. Kaushik, I'm sorry, Mr. Fukan. Mr. Deka's line has been recommended. And it also says by this minutes that out of the two provincialized tutors, the senior one should be considered for provincialization. He says his client is senior and his client is the junior one. But you have cancelled the provincialization of the senior one on 18/7/23. Correct? Instead. So this is not in terms of the.
there's a stay also when operating. That's why when we also it's
Of course, stay had to come. No, prior to the stay, pursuant to these minutes of SLSC, December 12, 2022, you have cancelled the provincialization of this respondent number 7 on 18/7/2023, which has led him to file a writ petition. And court has stayed it. If you had gone for the junior one, I don't think there would have been any problem. As it is, Mr. Dega's line is already recommended social science teacher. Language teacher, the senior one will stay, the junior one will go.
Yes, my lord. Very.
Last come, first go. Principle.
leave it to your lordship.
So if that is the case, there is a compliance of the court's order, compliance of the DSLC minutes. Of course, Mr. Das may challenge later on that.
He has been implemented as he's not come. He has to be implemented first.
You asked for that. His
The
name
IA
is
is
top
lying.
of the list, and his name is SH3. 96 I joined Bharat. He joined 2008, and he joined Bharat 2000.
See, what can be done now is respondents should act on in terms of these minutes, SLC minutes, 12/12/2022, and provincialize the social science teacher. And out of the, how many language teacher? 3.
3 now at present.
Out of the 3 language teacher, how many should go? 1 or 2?
No.
Just a minute.
That is there.
Mr. Fukan?
As per 3111, my lord. As per 3111, they should be.
No, as per page 77, which you just read, it says one language teacher who is senior amongst the two tutors provincialized against each school. But here there are three.
No, there are four language teacher, madam.
Ah, four.
Yes, madam.
After cancellation, my lord, his post was cancelled. The three remained there. We have some three there.
Four
Initially
teacher-
four
Yes,
provincialized.
initially four.
One cancelled, that is yours.
Yes.
Then three remains.
Three language remains.
Lordship will allow the improvement first, then I'll get my instructions also. madam.
Yes, madam. That's my,
If
my case
that
also.
be the case, because he's not implemented on date, so. let
But
us get the
so far as
instruction.
my case,
No, just tell me one thing. How many teachers are to be provincialized?
The general practices, my lord, as per 3111 is three teachers. One is maths and science, one is social science, and one is, my lord, language.
Understood.
Which- So these are the three.
Correct.
Based on the pupil teacher ratio, additional posts are created. ma'am. Based on
Correct.
on the
Correct.
pupil
The
teacher
proviso is there.
Yes.
If students exceed more than 100,
11
you have additional post.
Fine.
But in this case, what has happened? They have recommended and provincialized, they have recommended 6 posts. 6 posts, and ultimately provincialized 5 posts. And out of the 5 posts, 4 are language teacher. 1 is maths and science. But where is the social science? Not there.
yes, me.
Get my instructions also in the meantime. Because here, as per 3111, my lord, if your lordship sees properly, it is given there. It has to be, say, one maths and science, so science and mathematics, and then B is, my lord, social studies, and the C is languages. Then, my lord, for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under section 19 and 25 of the right to children and free, that is the pupil teacher ratio at 3111. So I will have to get the instruction regarding that.
And we also have come across this order pursuant to the disposal of the writ petition and when contempt was pending. At page 40, have you got it? Annexure 7. The last part, just see, in view of above. Kalapani so and so.
Of service number more than 5 people, as per clause 3111.
Mm.
That means, my lord, pupil, depending on the pupil teacher ratio, the standard procedure is 3. So depending on the pupil teacher ratio, they are saying that not above 5.
Not about 5.
Not
So
above
who will remain?
Exactly. So, my lord,
You want maths, you require 1 maths and science teacher. You require 1 social science teacher. And the remaining 3 can be the language teachers.
Yes.
And who among whoever's the junior most will go.
get my instruction, my lord, and I can place it. 2 weeks time may be given. In the meantime, I will get the instruction because it's, I think, a Google email.
Now, what about the implement? You want to be implemented in which case? No, just plus, please answer the question. That's all. 4498. Oh, not in Deka's case, in the other case.
In my case, my
Yes,
lord.
yes.
Your case is not 4498.
Your case too, Kiman. Yes, 4498 is my case.
Oh, that is your case.
Yes.
Okay. But why do you want to be implemented there? The respondent number 7 is there, is it?
Implement as respondent number 8, madam.
Any objection from anyone for implement?
Otherwise, if not, he's a junior most teacher. Let me first bring the instructions, then implement may be taken up.
Yes.
Because that will be better, my lord.
What instructions you want to take?
Regarding the, my lord, the pupil teacher ratio, first of all. Second of all, regarding the page 70, my lord, where you have indicated, my lord, that the 5 teachers, my lord. Why 5 teachers? If I can get that, my lord. Because the affidavit which we have filed has not highlighted that. So then let us bring that. My
Not
lord.
page 70, I think it's page 40.
Page 40.
Hmm.
Beg your pardon.
Page 40, there's already decision that we'll have only 5 teachers.
That part, the limited instruction I'll get, so that there is some clarity with.
If your lordship permits me, my lord, I'd like to make one submission, my lord.
Yes.
Since, my lord, it is admittedly, it is proved and from the scrutiny committee report on the hearing, my lord, I am the social science teacher as per the norms, my lord. On this point, this honorable court has passed the orders, my lord. There is clarified on this position. There is so far, if there is any dispute regarding social science or language teacher, so there is no dispute. Social science the distinguished post, and so far language post is concerned, the senior most teachers will be considered. That order, my lord, I have enclosed the page 50, my lord. That order clarified all the situation, my lord. There is no dispute with me. Why I should wait, my lord? There are enjoying the benefit of provincialization, my lord, but I am till date, my lord, despite I am eligible for the post-social science, my lord, I am nothing, my lord, I am doing nothing, my lord. They are enjoying their benefit.
But they have to make space for you, isn't it?
Exactly. And
You
my
cannot
lord,
enter unless somebody goes out.
Yes.
Out of 5, somebody shouldn't go out. Then you'll be adjusted according to that.
There is, but, my lord,
and
there
my
is.
lord, my lord, one more thing we have to get clarity regarding his case also, my lord, Musharraf Hussain, which is that if your lordship sees page 16 of the IA which they have filed,
Yes.
he's SMEs and social science, social study, SMEs and social study, not social studies alone.
Yes.
So that clarity you needs to be
Yes,
got
sir.
from the department. Because if your lordship sees the annexure A of page 16, Musharraf Hussain, date of joining is 16/6/2008, and his nature of
Let's write down. Pursuant to the order dated 16/3/2022, passed in WPC number 2143 of 2021. As well as order dated 20/2/2023, passed in contempt case C number 95 of 2023. The Director of Elementary Education has passed an order dated 21/6/2024, by which it has been decided that Kalapakani Sakatun Nesa Emi Madrasa can have only 5 provincialized teachers as per clause 3 bracket 1 bracket Roman small Roman 11 of the, what is the name of the act?
Yes, my lord, this
Page 101, isn't it? What was the page?
111, my lord.
111 of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017. Stop further. No, it's cancel further. In view of, to stop, in view of the above position, Mr. N. Fukan, Learned Standing Counsel, A. Fukan, Learned Standing Counsel, Elementary Education, shall obtain instructions as to who are the teachers who are going to be, who are eligible to be provincialized against the 5 posts, having regard to the provisions of the Act of 2017 by the next date. This matter again on so and so. How much time should you require?
10 days, 10 days, 2 weeks.
Okay, give a date of on 19/8.
Deeply obliged, my lord.
DPS.
This is item number
7 and
IA, my
8.
lord, IA. IA.
Look,
Call it, it is for another tomorrow.
item number 8, my lord, interim order may continue. In item number 8.
What was the order last time? Okay. Is it clubbed together with these matters?
Yes, my lord.
Yeah.
Up to it.
4/6/28.
Please write like that, one more line. Till the next date, interim order passed in WPC number 4628 of 2023 shall continue.
Deeply obliged, my lord.
I'll just rise for
Yes.
5 minutes.
Item 12,
But matter may be passed over the time being, but Mr. K. Gogoi will argue that he is another court, my lord. Mr. K. Gogoi will argue, my lord, he is in another court, my lord, and they pass over for the time
Hey,
being.
Gogoi. What is this matter regarding?
My lord, in brief, there were various polytechnic colleges which were established in the state of Assam, my lord, on various dates, my lord, from 2016 onwards. The petitioners, my lord, were appointed initially on a contractual basis.
What is this about regularization?
Yes, my lord.
You are 3F appointees.
Yes, my lord. We are 3F appointees. In
Hmm.
fact, the 3F appointees were culled out after the entire batch of ad hoc contractual appointees by fulfilling of certain norms.
Hmm.
So from 18/1/2025, my lord, we were absorbed on the 3F. Now, as I understand, our services has been done away with.
You're absorbed.
No, our services has been done away with, my lord. That after the expiration of the term of 3 months.
Hmm.
In the meanwhile, as I understand, my friend had just submitted that the entire posts in the polytechnics in the state of Assam
Hmm.
has been filled up by a subsequent advertisement.
Okay.
Now, my lord, in this petition, we have not challenged those advertisements. We have not sought to disrupt the entire selection process.
Then?
Our claim was based on the fact that the state had conducted a selection process in terms of the AICTE norms, the UGC norms, which are admitted, my lord. These are not disputed.
Even
facts.
for an appointment under 3F?
No, in fact, my lord, what had happened?
No,
the
conducted selection for what?
Conducted selection for
When you were considered initially for appointment.
Yes, ma'am. So the entire process was done in accordance with law.
So your case probably is that you have been considered
Yes, ma'am.
under the relevant provisions
We
for
have-
being appointed.
Yes, yes.
So even if it's an appointment 3F, you should be regularized.
Yes, in fact, my lord, there are two stages to
But
my
what right do you have? 3F is only for a temporary period.
Absolutely, my lord, absolutely. And the lordship is absolutely correct. In fact, even prior to 3F, my appointment was contractual, and that is the ground that the state has taken elaborately in the affidavit that since my initial appointment was under a contractual basis, I do not hold a claim for regularization of my services. Now, my lord, this contractual appointment is not a run-of-the-mill appointment as would happen in other matters, my lord. The reason I'm saying this is that in 2016, 17, and 18, when the various polytechnic colleges in the state of Assam, were instituted, we were the first batch of teachers and the authorities piggybacking on our appointment, albeit contractually, had gotten the AICTE norms. Our services, my lord, at that point in time.
Okay.
were-
Anyway,
Yes.
let him come.
In fact,
Mr.
my
Gowai,
lord,
come, we'll see.
if my lord, if my,
I was just asking you,
Yes.
just like that, what is the summary or what is the
Yes.
background?
In fact, there was a waiver on the part of the authorities which you have stated in the affidavit. My lord, if I may pray, my lord, since this matter is going to take
Some time.
my K. Gogoi would be here,
Hmm.
and this matter would ideally be argued by my senior Mr. M.K. Chaudhary.
Hmm.
In that regard, my lord, your lordship can kindly fix a date subject to your lordship's convenience on a hearing date. And the matter
Like
before-
today is a hearing date.
I understand, my lord. Since my senior is also
Hearing date to another hearing date.
just one.
When do you want it?
I'll leave it to your lordship's convenience. I'll leave it to your lordship's convenience. Since K. Gogoi is slightly caught up as of now.
End of August. You-
There's no date before August.
26 is a
6th August.
Tuesday. 26th August.
26th August, my lord.
That's prayed for. By Mr. You have Bhardwaj.
M. Sharma, my lord.
I'm sorry, as prayed for Mr. M. Sharma, learned counsel for the petitioner. Let's this matter for hearing. Admission hearing on so and so. On 26th August.
For hearing item 17,
May I please, Lordship? Case was earlier heard several times, Lordship, but
Due to related case of the respondents, the matter was ultimately adjourned, Lordship, and on the last.
By which court?
On the last.
By this
occasion-
court?
No,
No.
on the last occasion, your Lordship has directed to place the report by the respondents, Lordship.
See, I don't even know what is the case about.
Lordship, in this case, what happened, Lordship, the petitioner was.
Don't apply that shortcut method.
The petitioner was.
See, first of all,
Yes.
is the matter ready for hearing?
Yes.
You are ready, Mr.
No.
Tribaldar?
This is the instruction, not because the issue is.
No, what instruction?
Instruction is
It
regarding.
was listed before some other court. We don't know what instruction was required.
That is not the validity of the PhD degree obtained by the petitioner from Magadha University. So that is in doubt. So verification process is going on, and government has sent it for the screening before the screening committee for verify the validity and the genuinity of the PhD degree obtained by the petitioner. She is not the only case, Lordship. The many persons of the state, near about 700 or and above.
What is the case?
Lordship,
What is the case?
if Lordship allows.
Degree?
The petitioner was appointed as a assistant.
No. Just tell me what is the case? What is your basic case?
Lordship, she did not have the requisite qualification of PhD degree, and as such, she was appointed as a tutor, Lordship, tutor assistant teacher in the year 2021. If Lordship, it was the provincialist order, page 25.
Now, why has your case with along 700 others been placed before the SLC?
In the year 2022 itself, the petitioner has got the requisite qualification and accordingly placed the same in terms with the provincialist order as well as the rules. Because as per the rules, Lordship, if the state tutor teacher got the qualification, requisite qualification within 5 years, Lordship, then she will get the assistant teacher, Lordship.
See,
What is it?
it says re-verification of PhD degree.
Yes.
Why verification is required?
Because she obtained the verification from Magadha University, and according to the Magadha University in the year 2024 itself, during the pendency of the petition, Lordship, they provided the requisite report that the state qualification is a genuine, Lordship. As per their instruction, they give the report in the year 2024 itself. But we have filed this.
You have obtained your PhD from Magadha University.
Yes, Lordship.
Bodh Gaya. So there's some doubt about the.
Subsequently, they obtained the report from the Magadha University. The Magadha University in the year 2024 on 28/02/2024 itself. The same was placed before the respondent that the state degree is genuine. Now they are again placing the same before the screening committee. We have filed this petition 2023 itself. The Magadha University has given the report on 28/02/2024, and we are now in the 2025. I am entitled as per the norms as well as the provincialist order itself. If Lordship peruse the provincialist order, page 25.
Yes.
The page 25 is
Just a minute.
May it please, your Lordship. Lordship, this issue was before the screening committee as because of our High Court's direction, Lordship. As their High Court committee was constituted, Lordship, for examine the PhD which was obtained the outside Assam, Lordship, with a doubtful PhD is there some. Then, Lordship, some of
This
the
letter
Lordship,
given to me by Tribaldar,
Lordship,
Joint Director.
Lordship,
No, from Joint Director Higher Education
Lordship.
to Chairman Screening Committee.
Screening committee. That screening
It says re-verification.
re-verification.
That means one verification already done.
Lordship, some documents were submitted, Lordship. Some documents were submitted to before the concerned department, Lordship. After that, it was sent to the Lordship high-powered committee, Lordship. It's a screening committee is under the high-powered committee, Lordship. And that not only this petitioner's case, more than 500 persons case is there, Lordship. Not only this petitioner, Lordship.
So how
That's
long should
because-
it take then, this verification?
Lordship.
How long will it take, this
Lordship, it will
re-verification?
take, Lordship, at least 4 weeks time. Yes, because Lordship, more than 500 is there for final outcome, Lordship. Even list was prepared, Lordship. On the basis of the list, Lordship, that documents of verification was done, Lordship. It is not a single case that petition, only the petitioner's case, Lordship. 500 plus MPhil and Lordship PhD candidate, Lordship.
As because the particular PhD, whether they have done proper procedure or not, Lordship. Magad University has given a certificate that as per the records, he has done the PhD, Lordship. That part, no issue, Lordship. The main basic issue is that, Lordship, they have followed the principles laid down by the UGC or not, Lordship. That is the issue, whether coursework was done, whether the proper procedures followed or not, Lordship. Otherwise, Lordship, the in law is well settled in the, even, Lordship, the Professor Espal case, Lordship.
If my degree is not genuine, Lordship, as per their screening committee, then they may take action, Lordship.
That's why
But in the February 2024 itself, the Magad
that's
University
why,
has
Lord,
given the report, Lordship.
Magad University, not only Magad University, Lordship, other universities, Singhania University, Lordship, all are universities which are outside the state of Assam, Lordship, they have given similar type of certificate. They cannot give a certificate that that particular degree was not as per the UGC's regulation. Particular institute, they cannot say itself that it is not as per the guidelines.
Okay, anyway,
But
just a minute.
last 1 year.
See, the matter has been placed before the screening committee. That much instruction you have.
Like,
But the
otherwise-
time to be taken by the screening committee, that you don't know.
That part I am not, otherwise it will take at least 4 weeks time, and that particular screening committee was not constituted today, Lordship. It was 1 year back as per the High Court's observation, Lordship.
No, okay, so how, on what basis you are saying that it will take more than 1 month?
Lordship,
Because several orders.
more than 500 odd teachers is there.
I know that, last time 700 was said, today 500.
Lordship, more than
But
500 odd
where is
teachers-
the instruction that this will take a lot of
Lordship,
time?
More than 500 odd teachers and 200 MPhil teachers, more than 200 MPhil teachers. That's why
Understand.
figure is, Lordship, it's above the 700, Lordship.
Okay, so you only say that the committee was constituted last year
Lordship,
as per the court's order.
as per the court's observation, Lordship.
Exactly. So by now at least they might have started the
Lordship,
verification.
It's done, Lordship, as per screening committee prepared a list, Lordship. One list was placed, that was placed before the High Court committee, Lordship.
If I am not
Lordship.
700, I am only for the one petitioner, Lordship.
No, I understand. See,
Lordship, for getting the PhD.
oh, don't make all those kind of submissions. You see, you're just wasting the time. You want some time, that's all. I'm asking you, there's no such indication here that we need at least 4 months or 1 month time for instruction. It just says that it was placed before the screening committee. Now you have to tell me that what the screening committee is doing as on today.
Screening committee verifying the documents, Lordship.
No, as on what is the stage, so that we
Yes,
can give some
it's a-
time.
It's a verification stage. After verification stage, they give a report to the High Court committee, Lordship.
Screening committee again will give to the High Power committee.
It's a High Court committee. It's a two-tier.
Who will take decision ultimately?
High Court committee give a decision, Lordship, after it was sent to the Lordship appointing authority, Lordship. It's not a one-tier system, Lordship.
No, screening committee will, what is the job of the screening committee?
Job of the screening committee is that they have to verify. They have screening committee constitutional Lordship's expert.
After verification, what will do? What they will do?
After verifications, they have Lordship as a, they have issued some Lordship remark. After remark, whether it is as per the UGC's regulation or not, whether coursework is done or not, whether the duration
Okay.
period is done or not,
Then who will take a call?
then it was placed to the High Court committee, Lordship. Then High Court committee, after examining it, it was placed to the Lordship, the authority. Finally, it was appointing authority, Lordship. It is
So-
not a case that her service was not provincialized. Her service was provincialized, he is a tutor, Lordship. He is not getting the UGC's required full scale of pay, Lordship. If Lordship, the particular, if the High Court committee find that Lordship, that particular PhD degree is a genuine one, he will get the all benefit, Lordship, from the day of appointment, Lordship. It is
Okay.
not a case that she will not get anything, Lordship.
If that be case, then Lordship may pass a mandamus directing the respondents.
Just a minute, what is your claim in this
What
case?
done to the mandamus, Lordship?
Lordship, full scale, Lordship.
No, you're
Because
claiming what?
I am now getting the tutor, Lordship, tutor assistant. If Lordship, the Peru, the provincial.
You're getting tutor scale,
Tutor scale, Lordship.
and what is your prayer?
Lordship, prayer to
get-
get the UGC.
UGC scale.
UGC scale.
I have now getting I have
Okay.
obtained the requisite qualification.
Are you working as what? Assistant professor?
Yes, Lordship.
Or
Tutor
UGC's
assistant-
scale of pay,
tutor
Lordship, particular person should be the PhD degree as per the UGC's required norms, Lordship.
Okay.
Mere PhD degree is not enough, Lordship. So many things happen, Lordship.
But Lordship,
And a PhD
Mr. Gogoi, just a minute.
Lordship.
Just a minute, let me ask him. You are appointed as what? Assistant professor?
tutor assistant professor. Because
Tutor assistant professor.
the PhD
Just a minute, you just answer the question that all. Tutor professor, where?
tutor assistant professor on 5
Where are you working?
Lordship, Manovendra College, Rongia, Lordship.
And you're getting the scale of,
No,
Tutor-
lordship, fixed pay. Fixed
you're
pay.
getting fixed pay.
Fixed pay, lordship. Fixed pay.
You want the scale of UGC. And the respondents are saying that in order to get that scale, we have to verify
PhD.
and the way you obtain the doctorate, plus whether you have obtained the doctorate degree as per the UGC norms.
Yes.
That's the issue only, isn't it?
Yes.
So verification is going on.
Lordship, from 2021, I obtained I was appointed as the provincialized. My service was provincial on 5 to 2021, and subsequently I obtained a PhD degree in the year 2022. Lordship, I filed this report on 2023. The Mogot University has submitted by the report in the year on 28/02/2024. Several occasions are last. If Lordship peruse the order sheet, same submission was made by the respondent authorities.
There's an affidavit in possession file.
Itself, the matter was ultimately adjourned. And
Okay.
if that be so, then Lordship may pass on madam was directing the respondent to consider my case. And if my PhD degree is not genuine, then they may take action appropriate as per law. From 2022 onwards, I am deprived from my salary, Lordship. This is scale.
Today's submission is that, my submission is that, lordship, if her PhD degree is found to be a genuine one, then she will get the UGC scale of pay from the day of obtaining the PhD, lordship. She will be never deprived, lordship. So let's
Okay.
finish the exercise, lordship.
This exercise you have mentioned in your affidavit also, isn't it?
Yes.
Lordship.
There are 6 Lordship.
Affidavit filed in August 2023.
Yes.
So how long should it go on, this exercise?
So lordship may posted the matter after
Ultimately,
4
they
weeks.
are
I will
saying
come
about
up
the
with
500,
a.
700. I am only for the petitioner, Lordship. Lordship may direct the.
Yeah,
petitioner
screening
to
committee is
consider
not
the case.
sitting only for the petitioner, lordship.
No, this kind of argument will not do. You see, both of you should also understand.
That's why, lordship, I am submitting the lordship posted the matter after 4 weeks, lordship. In the meantime, I will come up with the latest instruction, lordship.
Okay, I've heard that. I've understood that.
Lordship.
Counsel for the petitioner, you should also understand you're concerned with your case. Now, respondents are concerned with all the cases.
But Lordship,
So they cannot single out one case and say that first we'll go into this and later on others 500 cases will take it up later on.
But I am before your Lordship.
I understand.
Relief, Lordship.
I understand.
2023 onwards, the same submission was.
Not only the petitioner's case, lordship, so many similarly situated cases pending before this honorable court, lordship. Not a single case before this honorable court, lordship. That's why the courts directed us to lordship verification part.
Okay.
If hers.
Okay, enough. We post it after 1 month.
Lordship.
Mr. K. Goswami, Learned Standing Counsel, Higher Education Department submits that the process of re-verification on the PhD degree obtained by the petitioner is still in process. And therefore, he prays for further 4 weeks' time to come up with the up-to-date instructions. In view of above, list this matter again after 4 weeks. On a date to be fixed by the registry.
At least fix a date, Lordship.
On a date to be fixed by the registry, they will fix a date.
Time being 14.
Review.
Review, madam.
Yes, what is the review? Which is the order to be reviewed?
Well, order lordship file,
Page?
page my lord, page 51, my lord.
What is wrong with this order?
There is nothing wrong in this order, my lord.
Then why
But
review?
for the only thing, my lord, the counsel for the petitioner could not place the case before this honorable court in proper perspective, my lord. The petitioner, he was working up to 2017 continuously. That
But,
aspect was not-
can that be the ground for review?
This petitioner-
Counsel for the petitioner could not argue properly.
Lordship, kindly
So
see-
that review should
Lordship,
be
kindly
done.
See page 52,
Is it that the ground?
page 52, my lord. After his transfer, my lord, the page paragraph 3, my lord, 6th line, thereafter, by an order dated
2000, the petitioner was transferred to Mornoi MB school. However, it appears that the petitioner did not join in Mornoi MB school and remained unauthorizedly absent. Actually, my lord, this order was subsequently stayed by the authority itself, and petitioner was allowed to work in the earlier school. He was working in the earlier school, where from he was transferred. He was continuing in that capacity, my lord. The headmaster of the school also certifies that he was working.
Where in Moroni MV school?
Mornoi, my lord.
Huh?
In Mornoi.
Maroi. It appears that the petitioner did not join Maroi
He
MV
was,
school.
he was working at Khandajan ME school.
Hmm.
From Khandajan ME school, he was transferred to Mornoi. That transfer order to Mornoi was stayed by the authority, and he was allowed to work at Khandajan MB school. And subsequently, this Khandajan MB school was amalgamated with the Khandajan High School, and he was working in the Khandajan High School up to 2008-17 continuously. That orders I have brought on record for the first time, my lord. The stay order as well as the, my lord, continuation.
So what was your case in the writ petition?
My case was that, my lord, I was working in the school, my salaries were not paid. The similarly situated persons, my lord, they were getting the salary, they were adjusted.
Your case was for payment of salary.
Salary as well as for adjustment against non-planned vacant post.
In which school? In which school?
In my lord, Khandajan ME school, my lord.
Hmm.
MB school. And this honorable court also directed the authority, my lord, to consider my case for adjustment after paying the arrears salaries. What they have done, my lord, pursuant to this order, they have terminated me with retrospective effect, my lord, 2001.
No, what is the ground for review? We are only concerned with review. It's not an appeal.
This, my lord, findings, paragraph 3, is, my lord, erroneous, my lord. Is not the actual findings, my lord, because, my lord, I was transferred to Mornoi MB school. That order was stayed by the authority itself, and I was.
You were appointed as teacher in Sadgari.
In my lord, Sadgari MB school, my lord.
ME school.
MB school.
Then
he was transferred to, my lord,
Khandajan.
Khandajan.
Then he was again transferred to
Mornoi.
Maroi MV school. What was spelling?
Maroi. I'm sorry.
Maroi.
Maroi.
Maroi MV school.
My lord.
And you did not join according to the order.
So, according to the order.
You say that you did not join because you were retained in Khandajan.
Yes, my lord.
Is that the reason why you won the review?
This is the order, lost will find at page 24, staying the transfer order, my lord.
So this is not reflected in the order.
Yes, my lord. This is not reflected.
Page 24.
Page 24, my lord.
Mr. Sharma, what do you say?
My lord, in earlier occasion, B. Kaushik was appeared here, my lord, and B. Kaushik opposed the grounds taken in this review, my lord.
Hmm.
And moreover,
We were supposed to file an affidavit in opposition.
we have not received any instruction, my lord. Also, 3 weeks may be granted so that we can file our affidavit in opposition here, my lord.
Why, it's coming for the first time over.
No, my lord. This is a 24.
You should have filed by now. 2024 matter.
Earlier on,
Earlier, my lord, we are not implemented here, my lord. On later occasion, we are implemented here.
Then review was filed against whom? Review was filed against whom originally?
In earlier, it was elementary education department.
Now?
Now, amended cost titles was there, and it is
No, my lord.
secondary.
Initially, as I was working in the ME school, my lord, in the writ petition, my lord, it was the, my lord, elementary education. Subsequently, as the school was amalgamated with the high school, then my lord, secondary school became a party.
Okay. So now you amended the cost title.
Yes.
Secondary has come now.
Yes, secondary.
When was the amendment done?
On, my lord, 27/8/2024.
27/8.
My lord.
So it was not last month or yesterday it was done.
1 year before, my lord.
Ah.
Almost.
So by now you should have filed something.
On last 3 occasions, my lord, counsel for the secondary education took time.
My lord, instruction will come from the elementary education department, so sometime is required, my lord.
You are paying for elementary or secondary?
Secondary is from elementary education department.
So who will give the instruction? Secondary or elementary?
It will come from the elementary education department, but ultimately, as the school was amalgamated with the secondary education department, so we will file the affidavit. my lord.
So who is the respondent, main respondent now? Secondary or elementary?
Secondary and elementary both are main respondent.
Where is the ground for review? You have not formulated the grounds, or there is the ground.
There is ground.
But see, the fact remains that today you say that your transfer was state, so you remain back in that school.
Yes, sir.
Whether that was your case before the writ court?
Yes, but that is why I am praying for review, madam, because that.
No,
it
no,
was
no.
workplace.
Not that is why. My question is that was the facts projected by you in the writ court that you had been transferred, but you could not go there because there was a stay off thing and you continued to remain in the school from which you were transferred?
Kindly take this review petition along with the writ petition, my lord, so that, my lord. The
Why should we do that?
text in the writ
You cannot
petition-
answer that now?
Yes, my lord, my lord, my instruction to the council, my lord, was not properly, my lord, placed.
Supposing you did not say something before the single judge or the writ court,
My lord, that is
tomorrow
why-
you file review petition and I forgot to say that.
My lord, that is why, my lord,
Can
I'm
that be a
saying
ground for review?
the vital fact, my lord, because I was rendering my service that has been negated by the authority, though, my lord, it is under the authority themselves, my lord, forwarded my case for release of salary.
Okay, I speak for Mr. U. Sharma, Learned Standing Council. What? Elementary?
Secondary education.
Secondary education and Mr. G. G. Pegu, Learned Council for Elementary Education. How much time?
3 weeks, my lord.
3 weeks time is granted for filing objection,
Another,
Of
a
the
copy of review petition.
counter affidavit to the
To
release
review?
petition.
A review petition.
Mr.
A copy of review petition. may be-
Also.
Give a copy, why should we incorporate all those things in the order?
Already we have furnished, my lord, I will furnish again.
Give them one more.
Yes, my lord.
18 and 19 for
Okay.
hearing.
How many matters are now?
May I please, your lordship? I'm appearing in the item number 19, lordships. My
Yes.
18 and 19.
Hmm?
My learned senior wants to start.
Huh?
My learned senior wants to start item number 18, lordship. I'm being led by my senior, Mr. Kiran Chaudhary. He's in election quorum number 1, but my senior can start his part now.
Better acquisition. Coming for a very long time.
You want to start?
Yes.
You can start. The court master.
Item 18. Hello, item number 18, your lordship, can see if
Item 18.
Yes.
This is item 18 or 19? What is the case? It's 18.
2020.
WPC 598.
Hello,
Yes.
although it is not, it may not be relevant, your lordship will kindly see paragraph 3.
it will be relevant in the other case,
Paragraph 10,
paragraph 3.
3.
Well, he is a MSc in botany and he's a PhD holder. Then thereafter also says that he is a permanent resident of Borough Territorial Region area.
Mm.
Your lordship got it.
Paragraph 3, yes.
Please. Especially that the petitioner is a permanent resident of Bodoland Territorial Region area and belongs to Scheduled Tribe Plains community and also proficient in speaking local Bodo language, whereas the respondent number 8 is not a resident of BTR area and belongs to OBC category. The respondent number 8 also does not know Bodo language. Your lordship will just note this.
Who is respondent number 8?
He is
Item
a
19.
petitioner. He is a petitioner. in
Item 19. Who filed first?
They file first.
They filed first. And they made you a private respondent there.
Yes, lordship.
And you file a writ petition
Yes,
and
we-
made them a respondent number 8.
Basically, he is the selection of principal of the college.
Which college?
Goreshwar College. Goreshwar College.
Sorry?
Goreshwar College.
Goreshwar College.
Under the BTC.
Principal.
Yes. Their contention is there in the selection process, their serial number is number 1 and I am in number 2. But although I am in number 2, the petitioner was selected and appointed as the principal of the college. Because
You were appointed.
yes, I was number 2 in the selection process
Uh-huh.
and he was number 1 in the selection process.
Okay, but you were appointed.
I was appointed because my lord, I belong to BTR 80.
Okay,
That is in the terms of terms of the advertisement.
okay.
So that this your lordship will know. And I'm questioning, they do not have their requisite qualification in terms of the UGC, in terms of the advertisement and UGC regulation, and therefore they are not qualified to be selected. Accordingly, we have filed a complaint before the Director of Higher Education in the BTC, and they have filed in my lord affidavit saying, my lord, that they are not, they do not meet the required qualification because on the basis of the inquiry I'll come to that, my lord. Your lordship will kindly see the advertisement now at page 24.
You say that you are local
I'm local.
and the other one is
The
the
Bodo
opposite part is not is a non-local.
He's non because
Okay.
this was the term. No, and also I see, my lord, petitioner in item number serial number 19, he is not qualified to be selected.
Qualification.
Yes. In terms of the advertisement and in terms of the UGC.
Yes, where's the advertisement?
Yes, advertisement, your lordship will kindly see page 24. Serial number 5, my lord. Your lordship got it.
Mhm. 24.
Too cold one.
Please reduce,
It is
increase the
difficult to
thing.
increase it.
Just
Ojan. Make it 24. Married man.
yes, serial number 5.
Minimum of 10 research publication in peer-reviewed or UGC listed journals and a minimum of 110 research score as per appendix 2 at table 2. I am not on that, I am not on this only. A minimum of 10 research publication in peer-reviewed or UGC listed journals. So my contention is that the petitioner in serial in item number 19, she doesn't have this qualification.
Minimum of 10 research publication.
In peer-reviewed or UGC listed journals.
UGC listed journals.
So my lord, we find, my lord, only one paper is UGC, UGC listed journal. The 10 research paper, she has submitted 10 research paper, as she says. And now the inquiry report says only one.
Who has done the inquiry?
Inquiry by the Director of Higher Education.
during the selection.
After the selection, we filed a complaint.
Okay, after the selection, you file a
Yeah, we filed
complaint.
Complaint saying that although he is selected, but she doesn't have the qualification.
Therefore, therefore you were appointed.
We are appointed because my lord, we belong to BTR first. But after they challenged this, my appointment, my lord, we challenged her qualification.
Okay.
So this qualification was, my lord, we have filed complaint before the authorities that the person who is selected at number 1, she doesn't have the qualification.
So the sequence of events is that advertisement, then the scrutiny of the documents, you were number 2,
But
the other one was number 1. But nevertheless, you were appointed.
because I belong to BTR.
Because you belong to BTR. Then he challenged.
Yes, now, yes, he
After
challenged.
challenging, the inquiry was done.
After challenging, my lord, we also challenged her appointment.
Okay.
We challenged her
And during the
appointment.
pendency, inquiry has been done.
Yes, we filed a complaint before the authority saying that, my lord, we have filed a complaint Now, your lordship will kindly see page 82.
You can go.
We have
You
all,
can go. I'll follow you when it's required. Page
82.
82.
These are the 10 research papers submitted by the respondent number 8. Ten research paper. Your lordship will kindly see, my lord, page 82. These are, this aspect of the matter will be clarified by the respondents, my lord. I'm just showing it, my lord, page 82. These are the 10 research paper which he has submitted along with the application form. Your lordship will kindly see page 82.
By whom?
This-
By respondent number?
Respondent number 8.
I see.
Who is the petitioner in item number 19? So short campus, my lord. Number one, my lord, two question falls, my lord, according to me, my lord, for consideration of the lordship. Whether, my lord, the petitioner being in a BTR area, whether he gets the preference, number one. If he doesn't get the preference, number two is that, my lord, whether the research paper submitted by the respondent number 8 is in tune with the terms of the advertisement and the UGC regulation. These are the two questions. So 82, my lord, this publication is there, International Journal below, my lord, International Journal of Research and Analytical Reviews, etc., etc. These publication names are there. Page 82.
Yes.
You have seen that. Has your lordship seen them?
Yes.
Now from page 90 onwards, if your lordship comes, this is page only one. Then other papers are all, my lord, from where it has been published, nothing is there. From 90 onwards, your lordship will kindly see. Only the names are there, where it has been published, nothing is there. From 90 to page 108. 9 research paper. This I am showing it from the copy of the representation. Then we file a representation, my lord, page 111. Your lordship may kindly note that only one paper publication details are there in below, my lord, page 82. In respect of the others, where published and all, nothing is there. Page 111, we have filed a representation before the VC, my lord, Vice Chancellors of the Bodoland University. Amongst others, my lord, we have stated, my lord, page 111.
Yes.
We have stated, my lord, may I read, my lord, 1, paragraph 2, 1. That sir, Srimati Pratibha Power did not submit the part B, etc. I am leaving these technical issues. Roman 3, para 2, Roman 3. That's after looking into documents submitted by respondent number 8, it is clear that she did not submit 10 numbers of research publications in journals of UGC care listed or peer-reviewed journals of repute at the time of application. That clearly disqualifies her eligibility and candidature for the post of principal post she applied for. So this is the grievance we have. And similar representation we have filed before the director, page 113. Director, Education, Bodoland Territorial Council. Now, in the affidavit in opposition, my lord, filed by respondent number 8. May I read, my lord, para 4?
Page.
In my journal, it starts from page 115.
The affidavit filed by
Respondent number 8.
reply.
Affidavit in opposition by private respondents.
Page 11154.
5.
155.
115.
Oh, 115.
Your lordship got it.
115 is what? Index.
Cost title, cost title piece.
Index.
So 115. Cost title piece.
Cost title base. Then 116 paragraph 4 is there, I think.
Pagination is something else. It's 115 is the
Cost title page.
index
Index.
of affidavit in reply.
My lord.
115 is the index for affidavit in reply.
This is affidavit in opposition. Opposition. Respondent number 8.
An affidavit in opposition filed by respondent number 8.
8.
Yes, I got it.
Pagination is different.
Not only different, you see, they have stitched the reply before the affidavit, before the counter affidavit. Counter affidavit is towards the last part.
My lord.
Anyway, I've got the page.
The paragraph 3. Paragraph 4.
Yes.
Let me read it. The deponent says that being duly qualified and eligible as per advertisement so and so, the deponent applied for the post of principal. It is categorically stated deponent fulfills all the required qualifications. Conditions of the said advertisement dated so and so, including condition number 5. The then principal received the duly filled applications of the deponent and with due acknowledgement and forwarded the same to the president of the governing body. If the deponent duly filled both part A and part B of the application form, which contains 9 pages, the deponent submitted all required documents as part B and part B. Now, she says, my lord, writ petition paragraph 5, the deponent does not admit anything which is contrary in the selection dated 6/4/23, the principal selection committee of the Bodoland University awarded 61.05% to the deponent, that is respondent number 8, and 57.23 marks to the petitioner and placed the deponent at serial number 1 in the select list, and the selection committee took resolution that the deponent was selected for appointment against the post of principal, Goreshwar College, Goreshwar, based on the performance in the interview held on so and so. Thereafter, on so and so, the governing body of the college adopted a resolution that I have already read, my lord. Your lordship must have seen who was selected. So she says, my lord, she got more marks than the petitioner. Paragraph 6, that with regard to the writ petition, deponent states that the respondent number 4 illegally appointed the petitioner, that is the present petitioner, by this order dated so and so in clear violation of the provisions of Rule 7A of the Assam College Employees Rules 2010. As the deponent has been selected as first position in the selection, the petitioner cannot be appointed as principal. Now, paragraph 8, my lord, that with statements in paragraph 10 of the are incorrect, motivated and baseless, and the same is stoutly denied by this deponent, and says that she has due qualification and eligibility for the post of principal as she fulfills the condition number 5 of the advertisement dated so and so. Deponent has got 10 of her research papers published in peer-reviewed or UGC listed journals, which are clearly mentioned in Part B at page 3 and 4 of her application form dated 13/1/2003, and those 10 research papers with cover page of the journals have been submitted along with the application form, which is mentioned at serial number 10/20 of the contents from page number 37 to 155. The cover page of the journals clearly shows whether the journal is peer-reviewed or UGC listed and its impact factor. The total research scores of the deponent comes to 434, and the research scores from the 10 research papers only comes to 170. As 6 of the journals where she published her research papers have impact factor about so and so. I'm not going to tell, my lord, this copies of the 10 cover page, page 139.
29.
Huh?
129.
129.
No, sir. 129, 139, 129 of Respond Assessor, and 139 of
Yes, 139, my lord. Sorry, my lord, 139. These are the 10 papers, my lord, she has submitted before the, along with her application form. Your lordship may note that much only.
Page 139.
Yes,
Annexure G.
yes.
Annexure G. All are peer reviewed, lordship.
This is submitted by
Us, lordship, the respondent number 8.
small number 8.
Yes. So all the 10 research papers are peer reviewed. The first page of the article, lordship, it shows that they are peer reviewed. Say for example, lordship, in page number 139, we have this Edu World. In this journal, lordship, a multidisciplinary international journal, peer reviewed. Then again at page number 140, lordship, this is also peer reviewed ISSN approved journal, International Journal of Research and Analytical Reviews, page 141, lordship. Again, this is a peer reviewed, lordship. I will show you. In the first page, international peer reviewed and referred journals, lordship. Then again at page number 142, again it is a peer reviewed, lordship. Education Today, a multidisciplinary international peer reviewed referred journal, lordship. Again at page number 143, 143, I think this is the same cover page of 142. At page 145, lordship,
Okay. How many in all?
total 10, lordship.
Okay.
Lordship,
Requirement is 10.
for us, lordship, these are peer reviewed,
The requirement is 10.
lordship.
The requirement is 10.
Recruitment as per the advertisement was 10.
10. So you have submitted 10.
10, lordship.
Okay.
And lordship, the inquiry, they are saying, lordship, UGC themselves, if we see the reply of UGC, they have nothing to object regarding our peer reviewed status of our peer reviewed journals, lordship. And lordship, the inquiry done by the education department, BTC, I don't know whether they are competent enough to.
Wait.
Lordship.
Let him complete.
Lordship, I just got carried away. I apologize, lordship. I got carried
If
away.
it is peer reviewed, my lord, I have no case, my lord. If it is peer reviewed and UGC.
We will.
You will get your audience. Let Mr. Das complete first.
Sure.
It's in the midst of argument.
So they have submitted, my lord. And accordingly, my lord, we have filed our affidavit in opposition. C. We have submitted our affidavit in opposition.
This is your writ petition.
Yes.
And they have filed affidavit in opposition.
Yes,
Yes.
lordship.
And you also have filed affidavit in opposition in the other case.
Reply. Yes, yes.
Oh, you filed reply.
In the other case, we have filed affidavit
Ah.
in opposition. We have said big. My lord, two questions that I have said, my lord. The first question is that, my lord, they are saying that in the terms of the advertisement, they will give preference to BTR. So now both are qualified. And so therefore, giving preference to BTR is not that. My submission is that. They will say, my lord, since they are number one, so they get more, the preference should go to them as per the regulation.
Yes.
And my case is, my lord, that since she doesn't have the qualification, so this matter has to be looked into.
Just a minute, huh? Mr. Das.
My lord. Yeah, wait, wait.
Yes, Mr. Das.
My lord, we have stated, my lord, that she has not enclosed all the 10 papers along with the affidavit submitted by her. In our reply, we have stated.
Okay. But you have shown me a few
Only the
pages here.
journal cover page has been given. And
Yes,
we-
covers given.
Covers have been given, the journals have not been given. Journals we have enclosed in our affidavit, in our writ petition, which I have already shown, my lord. That page, from that page 82 to 108.
Hmm. Yes, you have shown me something
Yes.
in the bottom of the page.
Yes, 82 to 108. These are the journals. She doesn't deny that. Now she puts the covers here.
But Mr. Das, you said that this has been examined by some committee.
Yes, I'm coming to that.
So what is their finding?
That I'm coming.
Because
That your lordship will get it at.
court may not have the expertise to
Yes, yes.
examine these
Definitely.
aspects.
My lord, one is, my lord, UGC has, as per the direction of this court, my lord, 10 papers, our paper, we have submitted 20 papers, research papers, and they have submitted 10 research papers. 10 papers submitted from our end and 10 papers submitted from their end. They have been inquired into by the UGC, as per the order of the court.
As
Now-
per the order of court.
Yes.
I
Now,
see.
UGC has filed an affidavit
Uh-huh.
here, saying that the respondent number 1, the respondent number 8, he has given only one journal, which is UGC care listed. They say, my lord, it is of peer listed or not, we do not know. That affidavit, your lordship will get it at
115.
page
124.
124.
It will.
124. What to pass, UGC care listed. UGC care listed was here. Here.
124.
124. It will be UGC care listed.
But 124 is affidavit. It's part of the affidavit filed by respondent number 8.
My lord, it is filed by the UGC man.
UGC is which respondent number?
That's one number 10.
10.
Yes.
Lordship, the running page should start from 359.
Huh?
359, please.
What do you want to? Maybe my lord 359.
359 should start. মানে আসিলে কাটি কাটি কেনে 124 টো কাটি running 359 359
Something wrong with the page.
page initial.
Check कर दिया. वही तो लगा था. ये भी check कर देते हैं. Okay. Your lordship got it.
124 has been renumbered as 359.
59.
Yes. Page 359. So there, my lord, in paragraph, they have stated what is the importance of the UGC peer listed and UGC care listed.
Which
Uh,
paragraph?
Paragraph 8.
8.
This is also not important for your lordship, my lord. Is what is the status of publication of research works or articles published in different journals written by the petitioners and the respondent number 8. The basic queries raised by the Honorable Court was as to whether which articles of the parties were published either in peer-reviewed or UGC care listed journals. So peer-reviewed, they said this is not within their purview, but they have commented on UGC care listed journals. Has your lordship got paragraph 8?
Yes, I've got it.
Yeah.
I just want to go back to the advertisement.
Advertisement, your lordship will get it at page
A
54.
minimum of 10 research publications in peer-reviewed
And
or
UGC list.
UGC listed journals.
Journals.
So the comment starts from paragraph 11.
Yes.
There's a chart.
Yeah, chart. So if your lordship goes through the chart, my lord, UGC council will reply appropriately, my lord. Five of the, my lord, journal published in UGC care listed, my lord, in respect of the petitioner. 5, my lord, your lordship will count later on, my lord. Your lordship will, because on the basis of the comment, they do not say it clearly, my lord. But I find, my lord, 5 of the journals, 5 of the journals published in UGC care listed, and in respect of the respondent number 8, they say only one journal has been listed in UGC care listed. That is at serial number 7, page 134. UGC will clarify, my lord, but this is in respect of the UGC care listed. Peer reviewed or not, they are saying that we are not the authorities. In respect page, my lord, the paragraph 11, your lordship will kindly see. Paragraph 11.
Yes.
Yeah. Although journals are there and they have given journal status, according to us, my lord, number 1 is UGC care listed, belongs to petitioner. Then number 2, number 3, number 4 is not. That UGC council will say, my lord, altogether 5 journals is UGC care listed in respect of the petitioner, and 1 in respect of the respondent number 8. Your lordship may kindly note that UGC will clarify. 5 journals of the petitioner has been under the, it is published under the UGC care list. All those journal status has been given, The Lordship may note that. Paragraph 11, in short one, it says, well, five journals of the petitioner out of the 10 is UGC care listed journals. It is published in UGC care listed, UGC approved list. And in respect of the respondent number 8, only one journals in UGC care listed.
How many you submitted? 11.
We have submitted, they have scrutinized out of 20, we have submitted total 20 research papers. Out of that, 10 has gone to the UGC. Because at the time of filing of the repetition, we have enclosed only 10 of our papers.
So 5 out of 10.
5 out of the 10 is UGC care listed. And in respect of the petitioner, and in respect of the respondent number 8, 1.
1 out of 10.
10. And in respect of paragraph 12, your lordship may kindly see. Paragraph 12. Paragraph 12. Paragraph 12.
Yes.
It says, Madam, that the UGC refrains from making any comments on the research articles which are claimed to be published in peer review journals because the UGC cannot comment on the standard and genuineness of the peer reviewed journal because the UGC does not keep any record of such journal which are not in its database. Therefore, it is difficult to comment upon the originality, standard, and the genuineness of the research work which are not published in a care listed journals. So therefore, they said they cannot give any comment as regard peer reviewed journals or not. They said that is not within their authority. Now, your lordship will kindly see affidavit filed by the director BTC. 16. That is at page in my, again that page differentiation will be there. In my page, it is 388. Page 388. Or 388, right? 388.
Filed by?
380, filed by the director.
Director of Education, BTC.
Yes.
In fact, who had made the assessment?
Experts, ultimately.
No, after the advertisement,
But the advertisement, the selection committee is there.
selection committee.
Selection committee, while our case is a selection committee, while taking the process of selection, they did not look into correctly whether the peer reviewed or UGC care listed journals submitted by the petition, respondent number 8. So therefore, we have filed a complaint before the authorities on the basis of the, as per the representation submitted as shown by them, that the petitioner, the respondent number 8 is not qualified because she doesn't have the journal
Yes.
that qualification.
What action was taken against your complaint?
That they have stated in their affidavit. I'll read paragraph 4 first, which will also cover number 1. Page 389. Paragraph 4, your lordship may kindly note. This is their answer to the first queries, my lord. May I read, madam?
Yes.
That as regard the statement made in para 5 of this instant writ petition, deponent begs to state that the advertisement dated so and so was published for appointment to the post of principal of the Goreshwar College by the president of the governing body Goreshwar, and as per paragraph 10 of the advertisement, the preference should be given to the candidates belonging to the Bodoland Territorial Council. paragraph next, my lord, 5. Regard to the statement made in paragraph 6, the deponent begs to state that the submission of petitioner's application as per the advertisement dated 1/1/23 and publications of research papers as well as respondent number 8 and other candidates in peer-reviewed or UGC listed journals are matter of records, and any statement made thereto which are contrary to and inconsistent with the records shall be deemed to have been denied. The deponent further submit that minimum 10 research publications, peer-reviewed or UGC listed journals are mandatory requirement to become eligible for the post in reference. So this is mandatory requirement. Now paragraph 12, your lordship. So there is no denial of the fact that the requirement is mandatory, which is the norms of the UGC also.
Yes.
Para 12. I'll
Yes,
listen.
read.
That merit.
Yes.
That as regard the statement to be made in paragraph 13 of this instant writ petition, deponent begs to state that it is a matter of records as regards the publications of the research papers by the petitioner as well as respondent number 8 in the peer-reviewed or UGC listed journals, and therefore in this context the BTC constituted a committee. Committee-wide notification dated so and so for re-verification research papers published in journals submitted by the petitioner and the respondent number 8 for the post of principal Goresh College. Thereafter, a meeting was conducted on 1/6/24 and accordingly minutes was drawn stating that the respondent number 8 has submitted 10 research papers and out of this only one paper has been published in a UGC care listed journal and is valid for consideration. Another 4 papers are neither published in indexed nor in peer-reviewed journals and hence may be rejected. The peer-reviewed status or validity of the remaining 5 papers could not be confirmed due to lack of pertinent information. Similarly, the petitioner has submitted a total of 20 papers. Out of these, 18 papers are valid for counting. 5 papers are published in Scopus Index journals and 13 in peer-reviewed journals. The remaining 2 papers are not published in peer-reviewed journals and hence may be rejected. So this is the reports of the experts, and your lordship will get it at page 394. Your lordship got it.
Yes.
This is the minutes of the meeting of the committee constituted for re-verification of research papers published in journals submitted by Dr. Pratibha Patwari and Dr. Pramod Mehdi for the post of principal Goresh College. The committee had a sitting regarding regarding research papers submitted by respondent number 8. Has submitted 10 research papers out of this only one paper has been published in UGC care listed journals and is valid for consideration. Another 4 papers are neither published in index nor in peer-reviewed journals and hence may be rejected. The peer-reviewed status or validity of remaining 5 papers could not be confirmed due to lack of pertinent information. Regarding research papers submitted by the petitioner, Mehdi, Dr. Mehdi has submitted a total of 20 papers. Out of these, 18 papers are valid for counting. 5 papers are published in Scopus Index journals and 13 in peer-reviewed journals. The remaining 2 papers are not published in peer-reviewed journals, hence may be rejected. A detailed report on research paper published in journals submitted by both the candidates is enclosed herewith. The committee has directed the Director of Education to forward the minutes of the meeting to the government of BTC for further necessary action. These actions they have not taken as yet, I believe, madam. So now, my lord, the consideration is, my lord, since they have submitted the report, constituted a committee and the committee has submitted a report. The report shows clearly that the respondent number 8 has only one published research papers in UGC care listed and others are not, my lord, valid. So therefore, my lord, and there is no affidavit to that extent, nobody has challenged this report. So therefore, my lord, I will go to the question of whether this peer review is necessary or not. Two judgments I will rely on. What has been there? One is of the this is, my lord, this judgment is, my lord, the advertisement was issued for 25 posts of principal, Manipur court, my lord. Paragraph 20,
Paragraph 28,
20.
20. Yes.
The petitioner contended that in the advertisement issued by the Manipur Public Service Commission, it has been clearly mentioned that one of the essential qualification is possession of PhD degree in the concerned elite relevant principles in the institutions concerned with the evidence of published work and research guidance. It is the common case of the petitioners in this petition that the said essential requirement consists of not only possession of PhD degree in the concerned elite relevant disciplines of by the concerned candidates, but there must be evidence of their published work and also of evidence of research guidance. The purpose is to show, my lord, that the research work, whatever the condition is laid down by the UGC, my lord, or as per the terms, it is a mandatory requirement. So unless one has that, so they are considered to be unqualified.
See that minutes constituted for re-verification,
Yes.
which you had read out.
Yes.
That came after the filing of the writ
It
petition.
is always like that, my lord.
No, before or after?
After.
After. So
It has to be like that only because, my lord, once the candidate here also.
finding is in your favor. Finding is in your favor, otherwise.
Take action on the same, because I say, my lord, she is not qualified.
And this minutes is also challenged by,
Nobody has challenged that.
not challenged.
Not challenged.
Okay.
And
That finding is neither here nor there. It is a case, my lord, the actual fact is different. I was recommended by the GB. Now the director, my lord, approved his name on the ground that he is a resident of BTR.
Okay.
That is the case. Now this is a counter blast. It is like a cross affair.
Okay.
I think some blast
It's a
is coming
cross
from the
affair.
other
No,
side.
yes. It's a cross affair, nothing else.
Mr. Das, you are reading item paragraph
Yes,
20.
Yes, paragraph 20, then your lordship will kindly see paragraph 30. Here, what I want to emphasize is this, the requirement of this research paper or research publication is a must. Unless you have one, you are not qualified. So ultimately it goes, my lord, it's a very lengthy judgment. Paragraph 20, may I read it again, my lord?
This is also regarding research.
Yes, principal of the college. 25 numbers of principal of the college were in the advertisement, and some they do not have the 3 qualified, and others who have been qualified, they did not have the research published. So ultimately, your lordship will kindly see paragraph 30. I'm trying to just shorten the matter, my lord.
30.
30. We are not able to accept the contentions of the respondents, the argument advanced by the private respondents that the requirement of research guidance of a candidate relates to the guidance received by the candidates concerned under a guide. or obtaining a PhD degree files in the face of the rules. The essential qualification for appointment to the post of principal as per the advertisement and the UGC norms is the possession of the PhD degree in the concerned elite relevance discipline in the institution concerned with the evidence of published work and research guidance. What the rules therefore require is that the candidate should be, there must be evidence of number one PhD degree, there must be evidence of the candidates having a published works research guidance. In other words, the candidates must not only be a doctorate in the concerned discipline, but must have a published works to his credit and must have guided some research scholars since the job concerned is for administration and teaching. This is what one gathers from the plain reading of the aforesaid expression. Now, paragraph 36, well, I'm coming to the shortcut things. Having taken this view, since we have found that there is no evidence of experience of the private respondents having validly guided researchers, we would hold that the private respondents do not fulfill the essential qualifications of having evidence of research guidance laid down for appointment to the post of principals of the governing college, and they are not eligible for appointment to the post of to the said post. So therefore, this they have found out, my lord, only when their selection was challenged before the court, because they did not have the essential qualifications of this research research guides. So therefore, my lord, it was challenged when they were selected, my lord. Somebody challenged their appointment on the ground that they do not have their essential qualification. This always happens after selection. So once a person has been selected who doesn't have the experience of research guide or the research papers, my lord, it will come under challenge. So therefore, this was ultimately set aside.
And the other one?
And the other one is, my lord, regarding the vice chancellor was selected without following UGC regulation. Single judge and division bench dismissed the writ petition. Supreme Court held that not following UGC regulation and it amounts to dehouse the UGC regulation and therefore set aside both the judgment of the learned single judge and division bench and appointment of the vice. Your lordship will find, my lord, paragraph 2. Paragraph 2, my lord. The appellant herein, original writ petitioner preferred the writ petition before the learned single judge, the High Court for writ of quorum to declare the appointment of the respondent number 1 as Vice Chancellor of the so-and-so Abdul Kalam University, Tiruvananthapuram, because that university had one guidelines and the UGC have another guidelines. Now, which guidelines will be followed? As void ab initio entirely on the ground that the appointment of the respondent number 1 dehouse the provisions of the UGC regulation, that the composition of the search committee was not in accordance with the UGC regulation 2010. Because the committee which was constituted, that was in violation of the UGC regulation. Even the recommendations and the appointment of the respondent number 1 as Vice Chancellor was not in accordance with the UGC guidelines. The research committee was required to recommend a panel of 3 to 5 names to this Chancellor. However, in the present case, only one name was recommended to the Chancellor, which was contrary to the UGC regulation. So therefore, anything which is in violation of the UGC regulation is liable to be interfered. And accordingly, the same was interfered in this case also, as they got selection of the Vice Chancellor, who was not selected by a committee constituted as per stipulations of the UGC guidelines. Now, your lordship will get it, my lord. Paragraph 18, my lord. Paragraph 18.
Of the writ petition?
My lord?
18 of the writ petition?
No, there's the judgment, my lord.
18 of the judgment, okay.
The short question, here the VC was, my lord, selected And not as per the UGC guidelines, the committee was constituted, not as per the UGC. May I read, Madam Speaker?
Yes.
The short question which is posed for consideration of this court is whether, while making the appointment of respondent number 1 as Vice Chancellor of the Abdul Kalam Technological University, the appointment should be as per the prevailing UGC regulations or in effect of the provisions of the University Act. Paragraph 20, identical questions came to be considered by this court in case of so-and-so and Kalyani Mativanan. Now the issue whether the UGC regulations shall prevail vis-a-vis the state legislation, state act, identical questions came to be considered by this court in the recess. While considering the appointment of the Vice Chancellors of the Sardar Patel University, Gujarat, it is specifically observed and held by this court that the appointment of the Vice Chancellor cannot be made beyond the applicable UGC regulation, even if the state act concerned prescribes diluted eligibility criteria. So it says, my lord, whether the state act or the university act will apply. Ultimately, page 26, my lord, paragraph 26. Paragraph 27. Thus, as per the UGC regulation 2013, clause so and so, the selection of the Vice Chancellor should be through proper identifications of panel of 3-5 names by a search committee, and the members of the search committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. It further provides that the visitor's chancellor shall appoint a vice chancellor out of the names recommended by the search committee. Therefore, the recommendations for appointment as vice chancellor should be sent by the search committee duly constituted, and that the search committee has to recommend the names thereafter, and thereafter the visitor chancellor shall appoint the vice chancellor out of the panel of names recommended by the search committee. The search committee must give proper weightage to the academic excellence, exposure. So ultimately, my lord, the paragraph 30. 31. In view of the above, and for the reasons stated above, the present appeals succeed the impugned judgment and orders passed by the division bench of the High Court as well as that of the learned single judge dismissing the writ petition and the refusing to issue writ quorum, declaring the appointed respondent number so and so of the University of Tirukanda as bad in law and or illegal and void ab initio are hereby quashed and set aside. The writ petition is allowed. There shall be a writ of quorum declaring the appointment of the respondent number 1 as Vice Chancellor of the so and so University as void ab initio. Because single judge and division bench, my lord, both dismissed the writ petition. It was challenged on the ground that the Vice Chancellor was selected not on the basis of the committee which is to be set up as per the UGC regulations. So that having not been done, my lord, this writ petition was filed, writ petition dismissed, division bench also dismissed. Supreme Court interfered in the matter, saying that the selection has to be on the basis of the guidelines stipulated by the UGC regulation. This is the crux of the judgment. My purpose of showing this judgment is that the stipulations in the advertisements and the UGC guidelines as regard research publications, it is mandatory. It is must. If one does not have the 10 research publications in the peer reviewed or UGC care listed, it goes. He is not qualified. So my representation having been considered by the authority, my lord, they have constituted a committee, and the committee has given a report saying, my lord, the respondent number 8 has only 1 UGC care listed journals and 9 are not there in the UGC care listed journal. So therefore, my lord, she is not eligible, and so therefore her selection at number 1 position is bad. So this is liable to be satisfied. Or otherwise, your lordship may direct the Director of Higher Education to take appropriate action on the basis of the report of the committee. And as regard the others, which my learned friend is holding, my lord, item number 19, already the BTR has submitted the affidavit, which I have already shown, that on the basis of the selection, they have selected a person who is in the BTR. Nothing wrong in it. This is in terms of the advertisement and purely on, mainly on the ground that the terms and conditions of the advertisement has not been challenged by the petition. This is my humble submission.
My lord, let me.
UGC may clarify and the
Yes,
position
yes,
as
yes.
regard the peer review or UGC.
My lord, I understand my learned friend contention in his case is that I do not fulfill the criteria of having 10 care review. No, care review, not peer review. He is talking of care review. Okay. He said, now what is the difference between peer review and care review? That you must have not explained in your writ petition. I don't know what is the meaning of peer review and care review separately. Now, therefore, you must make out a case in the writ petition because you are not supposed to argue a point of which you have not laid any foundation in your writ petition. Anyway, my lord, I'll deal with it. It's a very small matter, my lord. Now, his only contention is that I do not fulfill the requirement envisaged in the advertisement. Am I clear, my lord? Yes. My lord will kindly come to the advertisement at page 24. A person who has not been selected and he is holding the post of principal and he is seeking equity justice. Please come to page 24. He is not even selected by the selection committee. Till date.
Yes, 24.
Yes. Please come to point number 5, Miller.
Mm.
A minimum of 10 research publication in peer review or UGC listed journal and a minimum of 110 research score as per appendix so and so. Am I clear, Miller?
Mm. Yes.
A minimum of 10 research publication in peer review or UGC listed journal and a minimum of 110 score. Now, my lord will kindly come to my affidavit. At page number 139. We have given the, my lord, first page of the relevant, my lord, article, my lord. Page 139 is the writ petition, my lord, in the affidavit. And heading to please. What bumper? हम जाने मूल हेरी टू Now page 139, Miller. The name of the journal is Edu World. Am I clear, Miller? Page 139.
Yes.
Kindly see multidisciplinary international peer-reviewed referral journal. This is the journal, Miller. And my article, which has been published here, if your lordships will kindly come to page number 129, Miller. In the form of a chart I have given.
Yes.
Ensuring quality in higher education in rural areas. In that journal, it contains from page 335 to 340. And an expert body, my lord, a selection committee, they have already examined all these things. They have verified, they have selected me. He secured less marks because he does not have. Now, by filing a writ petition, he cannot stake a claim. In that judgment, which my learned friend was reading again and again, in the facts of that case, there was non-compliance. Therefore, this honorable court will not interfere with. How that judgment will have relevance in this case? First, show the facts. Where where is the shortcomings? First, my friend will have to satisfy your lordships Here is a case where respondent number 8 has not published any article in a peer reviewed journal. Then my lord will kindly come to page number 140. Page 140.
Yes.
The name of the journal is International Journal of Research and Analytical Reviews. Kindly see, International Peer Review and Peer Referred Journal, Open Access Journal. Now, my lord will kindly come back to page number 129 once again.
Yes.
My topic was a study on participation of rural community in higher education in South Kamrup area of Kamrup district. So, my lord, in this way, my peer review journal starts from page 139. It ends at page 149. I'll not trouble your lordships. So similarly, all the 10 journals where my articles were published and the list at page 129 contains the list of articles. So these are the facts, my lord. Similarly, my lord, from page 139 to 149 are the journals where my articles were published, and the list at 129 contains the articles which I authored, my lord. And these are as per the advertisement. It should be in a peer reviewed journal. It is in the peer reviewed journal. So, my lord, that judgment in a different facts, this honorable court may have recorded a finding that in the facts of that case, the particular writ petitioner was able to make out a case of interference. Therefore, court made interference. But that will not have any relevance here. Here we are concerned with a different fact situation altogether. So, my lord, their basic allegation is paragraph 8, 10 and 11 of the writ petition, my lord, where they allege that I have not been able to meet the requirements in respect of 3 areas, my lord. Sorry.
Yes.
I'm sorry, my lord. Their allegation in the writ petition are in para 10 to 13. That is regarding para 10 to 13 is regarding, my lord, that I do not have minimum 110 score. That is the first allegation. Then para 14, my lord, the allegation is that these journals are not listed in peer review journal. And para 15, their allegation is that I do not have the minimum 10 research publication. These are three allegations. First allegation is in para 10 to 13. Second allegation is in para 14. And third allegation is in para 15. And our reply is in, my lord, para 8 in respect of 10, 11 and 13. Para 10 in respect of para 14. And para 11 in respect of para 15 in the writ petition, where we have brought out everything, my lord. Now the issue is, who is this petitioner in the second writ petition? He applied for a post. He was never selected by selection committee. Now, my lord, who is this BTC to sit as an expert over all these matters, my lord? Are they academic experts? Are they, my lord, UGC? So, my lord, as far as this writ petition is concerned, as I have already submitted, kindly mark one date, two date, my lord. My name was recommended by governing body on 16/4/23. 16/4/23, my name was recommended by governing body to the director. If he is so vigilant about his right, why he did not approach the court immediately? So he was managing the BTC officers. He came to this honorable court on 3rd of February 24. That means after 10 months. Where is the explanation in the writ petition? 16/4/23, the governing body approved the selection of the respondent number 8, and that was sent to the director for approval, and he was sitting tight. If he is so vigilant, he should have immediately approached this honorable court. Kindly see the circumstance, my lord. In Barium Chemical, Supreme Court said that malafide or malice, it cannot be seen with naked eyes. It must be found out in the contextual facts. Now, this writ petition is preferred on 3rd of February 24. So, there is delay of 10 months and there is absolutely no explanation. Why he approached so late? End of the day, my lord, law aids the vigilant, not the dormant. Now, my lord, has he given any statement in the writ petition why the selection committee was wrong in not selecting him? First of all, you must establish your case before you try to find fault with others, what the others lack. First of all, what is your indefeasible right? What is that right which you came to enforce in this writ petition? End of the day, my lord, writ petitions are filed for enforcement of a right. What is that right which he had when he approached this honorable court? He had none, because he has not said anything about his right. All that he was saying is my selection is bad. But before you say my selection is bad, you must establish your right. You set over your right from 16/4/23 until 3rd of February 24. That is, after 10 months you came to this honorable court. So therefore, my humble submission is, my lord, that's why I said it is a counter blast. It is a writ petition filed with a malafide intention, just to, my lord, put pressure. So, my lord, I think this is a matter where experts have made selection. Now, this honorable court is not an expert. If your lordship finds prima facie that yes, what he is saying is correct, that I do not have any peer review journal, in a peer review journal, my articles were not published. Prima facie, if he can establish, then it's a different case. Otherwise, my lord, why he was not selected, why I was selected, that is not an area where a writ court would like to venture. Because writ court has always said that it is a field of the expert. Expert has selected me. And that selection of expert was approved by the governing body of the college. And governing body forwarded it to the, my lord, board of director. Now, my lord, will kindly come to the other writ petition.
Your writ petition was the first one.
Yes.
Isn't it?
Yes.
The advertisement was there.
Yes.
Then
He was not appointed, he was appointed.
recommendation was forwarded.
Yes.
And director, even
My lord, the dates are very few, my lord. I'll just give, kindly take 3543. If your lordship should kindly come to the list of dates on the very second page, my lord. They're very simple. 1/1/23 post advertised. Lordship has already noticed. 1/4/16, 20 ki bhul exactly. I think the date is wrong, my lord. All letters were issued. Eventually, my lord, 6/4/23, the interview took place, my lord, where the petitioner in this case, respondent in my learned friend's case, was recommended. Now, please come to page 25. An interview for selection of candidate for the post of the principal of Goreswar College, Goreswar, was held on 6th of April 23 at 11 a.m. in the premises of the Vice Chancellor's office at the administrative building of the Boroland, etc., etc. Now, these were the, my lord, members of the committee. Now, please come to the resolution. Following two candidates reported their presence at the time specified in the call letter. Pramod Medhi, that is the petitioner in the case where my learned friend appears, and Dr. Pratibha Patwari is the candidate, whom we represent. Selection committee interviewed both the candidates about their knowledge on different aspects of college, including functioning of college, the duties and responsibilities of the principal, his or vision as a principal for development of the college. Member of the selection committee found satisfaction in his/her performance and adopted the following resolution. Committee selected Pratibha Patwari for appointment against the post of principal based on performance in the interview held on 6th of April 23. So, my lord, the resolution of the selection committee was our client was selected. His client was never selected. If he is not selected, what is his right?
Come to the next page.
Yes.
This is where they
On-
added.
I'm coming now. On today's meeting of the governing body, a resolve to approve Dr. Pratibha Patwari, who was selected as the first nominee by the expert for the so-and-so, so-and-so, so-and-so. It is mentioned that Pramod Medhi, who has secured second position, is a permanent resident of BTR as mentioned in the advertisement. In this regard, Principal in charge GB President is authorized to submit proposal to the Honorable Director. So I was selected, he was the second nominee. Second position. Now, my lord, will kindly come to page 27. This is where, my lord, my shoe pinches. In exercise of the authority conferred under provisions of Rule 7A of the so-and-so rules, and in pursuance of the approval of the Secretary BTC, and is subject to discharge at any time without notice and without assigning any reason thereof, Dr. Pramod Medhi, so-and-so is hereby appointed as regular principal and posted at Goreshwar College. Now, my lord, here I have a point, my lord. Now, to select a person is one thing, and keeping somebody in second position or in the waiting list is quite another thing. If a person who is made as a waitlisted candidate, I think he still has some right. But if a person is a second nominee, then unless he's a second nominee, lordship will not recognize any right. That's an ancillary point. I'm just making that ancillary point, Miller. Now the question is, why this is done, Miller? Because he was never selected. I was selected. Then BTC files affidavit in our case and says, we have appointed him because we have given him preference, because he is a resident of BTC. And not only that, there is a clause in the advertisement. Now, my lord, if this is to be accepted, then my lord, Article 15 will have to be stricken off from the Constitution. We need not have Constitution. Why should we have Constitution? If place of residence could be the basis for classification, then my lord, we need not have Article 14, 15 and 16. I think Part 3 should be aborted from tomorrow onwards, my lord. Now, our High Court has said you cannot do it, number one. Our High Court, precisely on the same point. And secondly, my lord, Supreme Court has dealt with this preference clause in an advertisement. Supreme Court has said preference clause in an advertisement means when other things are equal, then a question of preference may come. In other words, supposing my lord both have secured same marks, then question of preference will come. When I have got 50 and you have got 48, because you are resident of BTC, there is no question of preference. Now I'll just place two judgments.
Or in other words,
yes,
it is not the case that only a resident of BTC can apply.
Exactly.
Anybody can apply.
Exactly. I'm obliged to your lordship, my lord.
Because-
For rather for father, judgment doesn't matter. Yes. It no copy here, sir. Huh?
What you want to say is that when all things are equal, preference will apply.
Yes. It will be 2000 হেৰি to দিয়া 2003 to দিয়া আছে আছে 2000 আগতে মোক দিয়াচোন এটি কোনটো Yes, it is. Yes. My lord will kindly come to page 349, para 11. Whenever a selection is to be made on the basis of merit performance involving competition and possession of any additional qualification or factor is also envisaged to accord preference, it cannot be for the purpose of putting them as a whole lot ahead of others, divorce their intrinsic worth or proven inter se merit and suitability duly assessed by competent authority. Preference in the context of all such competitive scheme of selection would only mean that other things being qualitatively and quantitatively equal, those with additional qualification have to be preferred. It may not, as somebody is a resident of some place, that cannot be an element of preference. What can be a preference? Supposing one with doctorate will be preferred. One with, my lord, some further academic qualification will be preferred. So, my lord, a place of preference, with all my humble understanding of our legal system, my lord, it can't be an element of preference. So now, my lord, there are other judgments on this point. I'm not multiplying. This is 2003 5 SCC 341 para 11. One more judgment, my lord. 2013 7 SCC 150 para 15. In fact, my lord, this para 11 is quoted here at page 157. At this juncture, has the lordship got it?
Yes.
We think it appropriate to advert when preference is given on the basis of merit and suitability. Conceptual preference fundamentally would mean that all aspects, namely merit, suitability, fitness, etc., being equal, preference is given regard being had to some other higher qualification or experience. What I said just 2 minutes back, my lord. So it could be some higher qualification, higher experience, merely because somebody is a resident of a particular place. That cannot be. Now, my lord, our High Court, precisely in the context of this very clause in the advertisement, has already dealt with the issue, my lord. That is WPC number 2776 of 24. Now, my lord will kindly come to para 16. 2776 of 2024. Dr. Madhav Sutradhar versus State of Assam. Please come to para 16. Petitioner in WPC so-and-so having secured higher marks than the petitioner in so-and-so and Srimati Korobi Das, there was no occasion to apply the preference clause in the advertisement in terms of the judgment of the Supreme Court quoted above. My lord, in fact, this 2003 5 SCC I have already placed. Consequently, the selection and recommendation of Korobi Das by selection committee as assistant professor, Department of Assamese is hit by Article 14 of the Constitution of India. The selection and recommendation of Korobi Das as assistant professor is accordingly set aside. It is also seen that petitioner in so-and-so has secured highest marks in the selection process. The selection committee, state respondents are directed to make selection and recommendation of the successful candidate solely on the basis of the marks secured by the candidate, in as much as there is nothing to show that the candidates that are mentioned in the tabulation sheet do not have other eligibility criteria to be appointed to the said post. The exercise should be concluded. So here in this case, my lord, it was also a case involving BTR, my lord, where the similar advertisement clause was inserted. It was in that context, my lord, this Korovidas's appointment was set aside, and my lord, the writ petition was allowed, and the writ petition was directed to be appointed, which direction I will also pray for in this case. Now, my lord, there is one more thing. Everything which is published in advertisement is not a gospel truth. I am relying on a Supreme Court judgment on that, my lord. Now, if advertisement contains a clause which is inconsistent with the statute, constitution, or laws, then, my lord, the advertisement, that clause is to be ignored. For that, my lord, 2018 3 SCC 55. Asa nahi hai? Nine. Was it 9? My lord, I'll hand over this copy, my lord. It's a very short one.
You read first.
My lord, 2018 3 SCC 55,
No.
para 27.
You read that first.
Yes.
Then you can pass it over.
Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. So, my lord, lordships will give way to statutory prescription in Article 14, 15, and 16, not to this clause in the advertisement. Otherwise, also, my lord, that is not the meaning of preference as they would like to give. Because, my lord, if you are making classification based on place of residence, then you are directly violating Article 14 and 15. So, Supreme Court says in para 27, my lord, I'll hand over a copy, my lord. Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Now, my lord, it boils down to a very simple case, my lord. A selection process took place. In the selection, I was selected by the expert. And, my lord, instead of approving my appointment, some overzealous corrupt officers sitting there, my lord, they have approved his appointment, though he was not selected. Now, what is the ground of selection? He is a resident of BTC, and there is a clause in the advertisement which permits giving of preference. So, my lord, I have already demonstrated the view of the Supreme Court on what is the meaning of preference. And on the same very issue, my lord, a single judge, the coordinate bench of this honorable court has already set aside such an exercise of power and has directed the authority to appoint the candidate who has selected based on merit and suitability, not based on preference. And as far as my learned friend's petition is concerned, my lord, I have already explained it is an counterblast. Only to, my lord, offset my legitimate claim in my writ petition, my lord, that has been filed just to divert the attention. And in that case also, my lord, first of all, he has failed to demonstrate what is his legal right. Which legal right of the petitioner has been violated by making my recommendation? His case is that I could not publish 10 articles in a peer-reviewed journal, which is not correct. His allegation is I have not secured 110 marks, which I have secured. So, my lord, all his allegations are absolutely in thin air without any substance. And the judgment cited by my learned friend may be an authority for the proposition in an appropriate case. If a selection is made without adhering to the norms of selection, then that selection is certainly needs to be interfered with. And for that, no judgment is required. If one can prima facie show that a person has been selected against the prescribed norms, the further judgment is not required. So therefore, my humble submission is, my lord, lordships will allow WPC number 3543 of 23 and dismiss WPC number 598 of 24 with cost. Now, I'll then make the submission why this petition should be dismissed with cost. Because he has prevented a legitimate candidate who was duly selected by the I mean, my lord, by the selection committee, prevented her from, I mean, joining. First, he must be selected by the selection committee, then only question of his approval of selection comes, my lord. And that to that extent, my lord, BTC authority also exercised very arbitrarily. So that is my humble submission, my lord. Judgment to go
Current status is that
current status is he is still there.
he is appointed, but there's an observation that's subject to outcome, that much.
Yes.
This they want.
Para 27, my lord, at page 64. There are other authorities also.
This was in relations to which advertisement?
No, this was in a different context, my lord. But the principle of law is, if advertisement contains any prescription which is not contrary to the statutory rules, then the prescription in the statute must give way. Must prevail. Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. There are line of authorities on this point, my lord. I just brought one.
You are adopting that principle.
Yes.
On the basis of the
Yes.
reference which has been introduced.
Yes.
Is that what?
Yes.
Okay.
So therefore, my humble submission is, my lord, it's a fit case where, my lord, as regards the affidavit filed by the Bodoland Territorial Authority, where now they have purportedly found that my selection was not proper because I only have one article published in the peer review. I do not know on what basis they are arrived at, my lord. They are not expert. And so therefore, my lord, lordships will ignore them. And kindly see, my lord, their stand. They have selected a person against the law laid down by this honorable court. In the coordinate bench judgment of this honorable court, it has already been held that you cannot make such selection. Despite that, they have done it here. Just as a measure of abundant caution, my lord, if your lordship feels that we need to counter that small affidavit because it was brought to our notice only today, lordship can reserve the matter for order, my lord. Meanwhile, we will by day after tomorrow will file a small affidavit on that. Because otherwise it will go uncontroverted. We will file a rejoinder to that affidavit where they have annexed that so-called recommendation of the committee.
Where is that? Let us see.
Yes.
You comment by the
My learned friend relied on that.
no, by which respondent?
Yeah.
UGC.
The second date, December.
UGC. Oh, you are for the BT. You are for BTC.
Yes. At page 395 is the report, my lord.
Just a minute. That 2018 3 SEC you are referring to para 25, is it?
27, my lord.
Or para 27.
First two sentences. So the entire basis of approving the recommendation is bad, my lord. Just for the purpose of records, my lord, because to be honest, this is not in our file. Only today we could lay our hands to it, my lord.
In the other case,
Yes, my lord.
affidavit filed by respondent number 234. But these were filed,
It was filed in August 24, my lord.
yes.
But somehow, my lord, this is not in our record. Today only from my friend, my lord, I got to know because when he relied upon it. Somehow, my lord, anyway, my lord, I'm not blaming them. Maybe they have served copies also, but unfortunately, it is not in our record. So what I propose to do, subject to what the lordships may say, my lord, I'll just file 2-page affidavit denying the allegations. So that, my lord, it does not go uncontroverted.
Annexure 1.
Yes. Day after tomorrow at 10:30, we'll file it. Otherwise, we will not argue any further. my lord. We will say, my lord, this is not the document which can be relied upon for the reasons to be taken in the rejoinder. It is like this, my lord. There is a particular body to take an action or select somebody. That body makes the selection. Some interested party files a complaint. Now a report is given.
Mr. Chaudhary, otherwise, this re-verification has been directed by this court or what?
No,
Not by this court?
no. And that to kindly see the point of time. Had it been an exercise undertaken before approving his case, I could have given a credence. It is not that also. The date is, my lord, 4th of April 24.
The committee sat on 1st of June,
Yes,
24.
yes. And the eventually date of the report is 1st of June. This is months after the, my lord, his approval. He joined in February 24. Had it been a case, my lord, this report was there, then a copy of the same was given to me, that why this is kindly show cause based on this finding, why your recommendation by the selection board, for governing body should not be rejected. I could have appreciated. Now, after appointment has been made, when the case is pending before this honorable court, that's what I said, my lord, just to ensure that this doesn't go uncontroverted, my lord, I'll just file a 2-page affidavit day after tomorrow at 10:30. Otherwise, lordship can reserve the matter for order, or as your lordships take a call, my lord.
Yes.
That is my humble submission. So I'll file by day after tomorrow. Deeply.
Yeah, for BTC. Basically, your stand is that there's a clause in the advertisement.
Yes, my lord. Before
Preferential
everything else,
clause.
just I like to make it clear, my lord. The subject of education is a transfer subject, my lord. BTC is a 6th schedule autonomy, my lord, a constitutional entity. And my lord, the subject of education, which also includes higher education, my lord, is under the control of BTC, my lord.
But then you send the
By virtue of
recommendation.
that, my lord,
You send the recommendation to whom?
you have sent the recommendation to the, my lord,
They do not.
director.
Governing body of the colleges send the recommendation to the authority,
To which authority is that?
to the vice chancellor and the.
We have sent the report to the director of education, BTC, my lord.
BTC
My lord,
only.
this committee was constituted on the basis of the representation that submitted by the petitioner, my lord. And the committee is competent, my lord. And the committee consists of experts, my lord, who are academics of different institutions, my lord. Amarjyoti Burman is one of the 5.
Okay, but is it discernible from the composition of the committee?
My lord?
Is it discernible anywhere that
Yes, my
these are the experts?
These are the experts.
Where's that?
My lord, Amarjyoti Burman designation has not been put here, my lord. He is the Secretary Education, Bodoland Territorial Council, my lord. Manjit Basumatari, member of the committee, my lord, who is the academic register, Bodoland University, my lord. And Mr. Dr. Badan Borman, assistant professor, Guwahati University, my lord. Dr. Tilak Hazarika, who is a member, associate professor, Cotton University, my lord. And JP Brahmo, member secretary, who is the library and informative information.
From where you're saying that?
Well, these are the information. This is not on record, my lord.
This is your knowledge. We don't know about that.
My lord, I was
You have not divulged that.
instructed to say.
No, you may know each member, their
my
designation,
lord.
their expertise. You may know that personally, but we don't know.
This is what I asked the authority, my lord. Who are these people, man?
That's what. But that has you have not divulged in your affidavit.
Nowhere it is
Have you?
reflected, of course.
They will be having records, but.
No,
If
that's
necessary, my lord, I can bring.
No, that's another thing, you see. We cannot enlarge again and again like that.
As my senior friend has
Whatever is
already
there, we'll have to.
read out the affidavit, which is
See, tell me one thing.
my lord.
If you come to the earlier writ petition, you're not there.
Yes, my lord. Yeah. In the earlier repetition,
You are
my
there
lord,
also.
no, my lord. Santanu Bora was applicable. He is there.
You have a copy?
In that writ petition also, the affidavit has been filed, my lord.
No. Do you have a copy of the writ petition? 3543. Do you have it? 3543. You have it? No.
Sorry, my lord, I don't.
But you are also a respondent here, there, isn't it?
Yes, my lord. In that writ petition, my lord, Santanu Bora has been appearing. My colleague.
Where is he?
He's not here, my lord. He was there.
He's not here, that we can see, but why is he not here?
But
He,
there,
he was asked you to argue on his behalf.
Moments before he was there, my lord.
The file is with him.
Yes, my lord.
He-
Yes, my lord. I have this copy.
You have a copy.
Yes, ma'am.
Come to page 24, Annexure C.
Yes, ma'am.
This is the mark sheet. I mean, the score.
Annexure C.
C is. Total marks is in the end. What is this average? How does it mean? Pramod Medhi, that is the appointee.
Pramod Medhi was appointed.
This is the mark sheet, is it?
Yes, ma'am.
How do they get the mark sheet? I mean, the marks score?
Code is Pramod Medhi
How was it obtained?
57.20.
How they have annexed it? So 57 and 1 is 61.
61.05.
Correct. Then you come to Annexure D. Next page,
45 we have here.
RTI. Where have you mentioned that? Or any covering letter? Normally you should disclose that. I file RTI and this is what was given to me like that. Otherwise, you may obtain like that unofficially somewhere and somebody may give you. See, Annexure D come to Annexure D. Now it is the what is this? This is the selection committee.
Yes.
Correct.
Committee selected by.
Selection committee has made that resolution after interview.
Bodoland University. Selection committee.
There was a selection committee constituted, isn't it?
Bodoland University. an interview for selection of candidate. for the post.
What is the name of the committee? Bodoland University. The university is Bodoland University.
Yes, my lord.
Last. Principal Selection Committee, Odisha Police on issue.
Principal Selection Committee. Resolution is this one. Committee selected so and so. Now the matter goes to the governing body.
Yes, ma'am.
Governing body perhaps would have said that this is the person recommended.
This committee is constituted.
Governing body, my lord.
Ought to have said that Miss so and so is recommended. But additionally, they have added one more name. So and so secured second position and a permanent resident.
Governing body.
So this is where the directorate has come to the thing. Deciding to, okay, if that is the case, there's a clause, we take this person instead. Then the controversy starts. Writ petitions filed.
For the affidavit in the second past writ petition, my lord. Affidavit.
Then after this writ petition, then there's a complaint
Yes, my lord.
filed.
Complaint was filed before the, my lord, the director.
When?
BPC.
When?
In the writ petition. Second writ petition. Page.
Was filed on 1/2/24. Page 111 and 113. I've shown my lord, I've read it also.
Space 111, NXR 13, my lord. Oh, no, this is to the Vice Chancellor, my lord. Baroda University. This is NXR 14, my lord. 113 page. In the second writ petition.
After filing of the writ petition, that representation came. So on the basis of this representation to the Vice Chancellor as well as the Director of Education. You
Intervene in the matter, I mean, acted on this.
you constituted that
Constituted committee, my lord.
committee.
Yes.
That notification is there, mother, and provided. Notification copy.
Also, no?
Now, what will happen to the other finding? Based on which that recommendation was made? You tell me. This annexure C. Annexure C. Marks is given on what basis?
And your lordship was querying whether who are there in the committees, whether
No, that's okay.
that is in the affidavit they have stated.
No, I'm sure there must be somebody expert, but the thing is that
Principal Selection Committee.
Principal Selection Committee, what is it? This is a constitution.
Constitution of the committee, whether your lordship.
This is for re-verification.
Yes,
No,
For re-verification, my lord.
no, I'm asking you about the principal
stated in their affidavit.
Principal Selection Committee.
My lord.
Where is their constitution? If it's not there, you tell me on what basis these marks are given. This is on the basis of the research. Marks.
In the first writ petition, my lord.
Yes. This
Actually,
57.
In the first writ petition.
57 to Pramod Mehdi and 61 to Patwari. These marks are given on what basis? It's given by different candidates. Average is taken.
This will have to be explained by the by Lord Bodoland University, who is also party. Is it party now? Bodoland University is also a party respondent member.
Okay, that is one thing. Now, these finding or this principal selection committee's findings is pitted against the finding of this re-verification committee.
Yes.
Which will prevail?
My lord, since this is a competent committee and the committee consisting,
Competent is one thing, but the timing also you see.
because only after the representation, our intervention came. My lord. Before we were not aware of this. And the findings of this committee also is not subjected to challenge in any petitions or any other.
That is one side of one way of looking at it. The other way is whether it should be relied at all.
Definitely, my lord. The Bodoland Autonomous Territorial Council is the
Otherwise, in every appointment you make,
and it's a subject.
you act upon the recommendation made by somebody, you act upon it and you appoint somebody. Okay. Then few months down the line or few years down the line, somebody submits a complaint. Then you will constitute a committee. And committee comes to a different finding and you say, okay, we rely upon the finding of the committee. There will be no end to it. What is the purpose of having that special committee then?
Since we have received the complaint, my lord, we have to act on and verify the allegations.
It is always after the selection process, the challenge starts. Even the APSC selections are set aside on the ground of these people doesn't have the qualification, that the marks are given in a wrong forum. Your lordship is to consider, may I just point out, my lord, if you allow with permission?
Yes. Yes.
My lord, your lordship is to consider two aspects of the matter. One is that the appointment of the petitioner as regarded BTR, that may not be so favorable to me, according to me. Well, I'm submitting, but what they have done is, my lord, both are qualified. Both are qualified for the post of principal. It is not that the petitioner in the item number 18 is not selected. He is also selected and the petitioner number 19 is also selected. Both are selected, so they are to give preference to item to the BTR candidate. This is my submission as regard the candidature. Second is, my lord, when I find, my lord, because it proceeded with the RTI filing, whether the petitioner has got qualification, petitioner in item number 19 has got qualification number. And we find, my lord, here after seeing the papers that she doesn't have the qualification.
So that means that special committee who was doing the selection,
Not only that, my lord.
they were blind. They didn't see anything. They were just sitting like that.
They have constituted only after receiving my complaint. Before that, my lord, the selection committee, in many cases, it happens, my lord, when an application is filed for the post of principal, they enclose the copy of their research publications. And they, without looking into it, sometime, my lord, they select those persons.
That is why I'm saying
So they make it visible.
the special committee constitute is blind.
No,
Simply seeing the name and few marks they gave.
No, special team constituted by the government, because we have filed a complaint before the VC, and we have anybody, even now, if your lordship direct, you please find out whether she is PR listed or UGC listed journal has been given. I am ready, my lord. I have no complaint. If she is PR listed, if her journals are PR listed, I have no complaint, my lord. She is eligible. What I am challenging her roots in the matter, my lord, that she is not qualified.
No, I understand that.
So therefore, if your lordship
So
is
all
not-
these aspects ought to have been seen by the constituting committee.
No. Committee at the time of selection, yes, they ought to
They did
have
not
select-
see.
They did not see. That's why we came. That is why we came.
So
Otherwise, my lord,
so that's why I'm saying why they did not see. That means they blindly gave.
that is what they
Huh?
do, my lord. Every time, even Assam Public Service Commissions, even other. That's why we come before the court Even the two judgments which I have relied upon, those judgments also selection has been done in violation of the UGC rules. This selection has been set aside. In those two judgments, your lordship, one is VC, another is three principal of the college. They have been selected, my lord, overlooking the provision of the by the selection committee. So what we challenge always is, my lord, the selection process. Selection. Some unqualified persons have been also qualified. We will come. Only after the selection process only we come to know. These two judgments which I have annexed to, my lord, these two judgments will show one VC's appointment which was not interfered initially, my lord, by the single judge and the division bench of the High Court. This was interfered by the Supreme Court, saying that, my lord, VC's selection is not in consonance with the UGC regulations. And secondly, my lord, the three principals, the Manipur division bench judgment, three principals who have been selected, my lord, they were unqualified, but they were selected. So this happens only after the selection process. So therefore, what I submit, my lord, since rightly or wrongly, there is a selection committee, we have given a representation. On the basis of the representation, the government has acted upon it. They have constituted a committee, and the committee has given a report saying that this person has got only one UGC care listed journal. Other 9 are not UGC care listed. So therefore, she is not qualified. Admitted in my lord. Otherwise, also, if I'll request your lordship, my lord, pray for your lordship. If your lordship is not happy with the decision of the BTC authority, your lordship may direct any other authority to look into. I have no qualm about it. Any other authority may look into it. Whether this person with the petitioner number 1, respondent number 8, has got journal published in UGC listed. If she doesn't have, if she has, I have no case. We have filed it because we have made out a case showing that first of all, your lordship will kindly say, first of all, that RTI application we have given, because part A and part B form is there. One form, your lordship, it has to come serially. Your lordship will kindly pay page 56 of the writ petition. Our case is very simple. She doesn't have the qualification. How are you selecting? That already আছে পানি।
Mr. Das.
Yes.
Mr. Chaudhary said that he wanted to file a small reply on that affidavit.
I have no
Oh.
on now,
So-
after conclusion of the hearing, if he was to file a reply, I have no comment. But
So-
on the what I wanted to say is that I have annexed her 10 documents, 10 papers, 10 research papers. And what she has done is, she has given the front page of the article, I mean some publication. So somebody has to decide whether this is peer reviewed or UGC can listen. Who is going to decide? Either because we have filed a complaint before the authorities. Authorities have constituted a committee. Your lordship may believe, may not believe. I'm not saying so. You may believe, there is no reason not to believe it. But for any reason, if your lordship doesn't believe it, your lordship will have to give it to the Cotton College or any other university. I am ready for it now. If anybody says her papers are UGC care listed or peer listed, I will withdraw my petition. This much I can say. To my knowledge, I have also verified with the help of some professor. I find only one paper is UGC care listed.
See, what I intend to do is perhaps since we have heard this matter,
Yes.
they want to file an affidavit, let them file. We post it on Monday.
Let him, after 1 week, let him bring the records also. Your lordship will see the original things. Let them file, let them bring the record.
No, they have produced the findings. What is there in the records?
No, whatever
What will be
your
required?
lordship wanted to see how they have,
Within
taken, I thought
affidavit.
the records are there.
The file is in affidavit, that, I think that's sufficient.
You have filed it, isn't it?
In affidavit, we have.
You have filed it. So Monday we'll list it and let the thing be there.
Yes.
And
You may produce records. Yeah.
why? No, I'm not. He himself said that he's not going to make any more submission. He wants that affidavit to be on record. That's all. So and we are not going for any such kind of hearing anymore.
Yes.
So that affidavit be there, then I'll consider and pass necessary orders. Only for that.
And only one aspect I want to close. My learned friend says that I'm not selected. Well, both are recommended. Question of mine not being selected doesn't. I'm also selected, but I'm number 2. He's number 1. What my prayer before the court is that I'm also selected. My learned friend is saying that I'm not selected. How is he saying that I'm not selected? Both names have been recommended. And the inquiry report, my lord, which they have filed, is in the form of affidavit. They have not challenged. And if I'm saying before the court with my all conviction that your lordship is not happy with the inquiry, my lord, your lordship may give direction to anybody to inquire into the matter, even during the pendency of the case.
Please write hard in part. List the matter again on 28/7/2025.
My lord, we record our presence.
So meanwhile, the
Yes, that is
the petitioner in WPC number 598 of 2024 may file a reply to the affidavit of position filed by the respondent numbers 2, 3, and 4.
my lord, petitioner not respondent number 8 in WPC 598.
Oh, I'm sorry. Meanwhile, I said petitioner, isn't it? Meanwhile, instead of petitioner, meanwhile, the respondent number 8 may file so and so.
Let me record our
Mr.
presence.
Samo, you're for which respondent?
UGC, number 10.
Next para, you write. Mr. B.D. Das, Learned Senior Counsel, appears for the petitioner in WPC number
598
of 2024. Mr. K.N. Chaudhary, Learned Senior Counsel, appears for the petitioner in WPC number 3543. Mr.
Rabha, my lord.
S.R. Rabha, Learned Standing Counsel,
BTC.
appears
For respondent number 2,
Learned
3, and 4.
Standing Counsel BTC appears for the respondent BTC. Mr. A. Chamo, Learned Counsel, appears for what is the
Respondent 10 uses.
what is that? Appears for the respondent UGC. And who else?
Respondent number 10 UGC.
Respondent number 10 UGC. Mr. J. Lotha for governing body of. No, give the name of the governing body. Name of the governing body. I said the name, not the number. Governing body of Goresh. Of Goreshwar College. Huh? And Mr. K.K. De, Learned Counsel for Bodoland University.
Excellent.
The next date, I'll show your lordship, the APSC selections are also set as one judgment. Set aside on the after selection process.
Next day will be just foreclosure. I think you all have made your arguments. Okay.
No, I'll show
I have-
on judgment.
Sure.
Consideration for before lottery,
Ah.
whether peer review is necessary. If it is necessary, then whether they are peer reviewed or released.
Staple this inside. And you do one thing, you get a printed copy of this. This judgment. Okay. This, you get it printed.
No,